With your kind leave, my lord, this is item number 167 of
Original site.
no, my lord, appellate.
Original site.
Original site mentioning, if any.
History.
Appellate side is not.
Appellate site mentioned.
After original site.
Okay.
Item number 1.
Well, item number 1, I appear for the state.
My lord, for West Bengal Transport Corporation, need.
My lord, if I may indicate,
least-
my lord,
2 weeks time, lordship.
one more.
And fire has been broken out at our office in Mirza Galib Street.
What has
So
happened?
fire has been broken out, lordship, in our office premises.
Petitioner is not appearing, my lord.
In Mirza Galib Street, my lord.
When?
Yesterday, last night, my lord.
My lord, if my lord remembers this matter, on 2 occasions the petitioners did not appear. Then on the last occasion, the petitioner appeared and they said that they would serve papers upon us. We don't have the papers.
Yes.
And they undertook to serve the papers. And again today, my lord, they're not appearing and they have also not served the papers, my lord. So they are not interested in pursuing the matter, my lord. I was humbly praying if the matter could be dismissed.
On the last occasion, on behalf of the petitioner, it was stated that the copy of the writ petition will be served within 12th of August.
It has not been done.
Today is
18th.
19th of August.
19th. I am not more for the petitioner, lordship.
Whom
For the West Bengal Transport Corporation, lordship. Respondent.
Petitioner not appearing.
Petitioner not appearing. Last occasion, lordship, there.
They're not pursuing the matter, my lord.
Yes.
The report file
Should-
quickly
should-
now.
Then
Yeah, बोलो ना, we are praying for them. हाँ, कितनी ना, भारत.
the petitioner was not represented either on 3rd of July or on 17th of July. Subsequently, on 7th of August,
है ना, अलग अलग.
petitioner was represented and had submitted that a copy of the writ petition will be served within 12th of August 2026. But today, none is representing the petitioner,
And service also not.
and the learned counsel representing the state of West Bengal submits that they have not been served with the copy of the writ petition as yet. In such circumstance, for the ends of justice,
My God.
the matter is being fixed. সামনে বুধবার কত তারিখ? 20 সামনে বুধবার তাহলে 20 বুধবার মনে হচ্ছে খোলা নেই. 28th. Let the matter appear on 28th as last chance. Full stop. And the period for serving copy of the writ petition is extended till this week. Full stop. The petitioner is directed to serve copy of the writ petition within this week upon the learned counsel representing the state.
Grateful, madam.
Item number 2. Item number 2, my lord, I appear on behalf of the respondent CSC.
The petitioner,
My lord, I will only pray, my lord, if my lord kindly take it up next week, my lord. My lord, today there is some difficulty on my part, my lord. My lord, there was a direction of service I have served already.
Yes.
I'm for the petitioner, praying for Passover.
Next week, any day next week, my lord, subject to your lordship's kind permission.
28th, Friday.
Friday, my lord.
How do the petitioner is being represented. Full stop. The learned counsel representing the Calcutta Electric Supply Corporation Limited seeks an accommodation for a week. Accordingly, let the matter appear on 28th of August.
I'm grateful, my lord, deeply obliged.
Item number 3.
I appear for the respondent bank.
My lord, I'm appearing for RBI Ombudsman.
Most probably on the last occasion also the petitioner was not represented. Now, there were directions for exchanging affidavits. We have done so.
My lord, my affidavit in opposition may kindly be kept on record.
May I be favored with
What the use of having the affidavits if the petitioners are not there? Let it be kept with you. Let it be fixed on 28th.
and may I be favored with a copy?
I shall convey to my AOR.
On behalf of the Bank of Baroda, you are representing Bank of Baroda. You have already filed affidavit in opposition. It is in the record. Do you have a copy of the affidavit in opposition?
I have the original with me.
Do you have the copy?
A
You
copy.
can serve it
Yes, I shall. I will
during the
convey.
course of this day.
Yes, my lord, I will
Then-
convey to my AOR and we shall do it. Grateful, my lord.
Khan is representing the petitioner. On the last occasion also, that is on 24th of July, none had represented the petitioner. Full stop. Affidavit in opposition is being filed by the Reserve Bank of India. Let it be kept with the record. Full stop. As regards to serving the copy, any order is required.
No, man. If lordship wishes, your lordship may record. Otherwise, I shall serve.
Last sentence. On behalf of the Reserve Bank of India has been filed today without serving copy upon the Bank of Baroda. Affidavit in opposition on behalf of the Reserve Bank of India is being filed today. Let it be is being filed today without serving copy upon the learned counsel representing the Bank of Baroda. Full stop. Let the affidavit in opposition be kept with the record. Let the affidavit in opposition be kept with the record. Full stop. The learned counsel representing the Reserve Bank of India is to serve the copy of the affidavit in opposition to the learned counsel representing the Bank of Baroda during the course of this day. Full stop. For the ends of paragraph, for the ends of justice, let the matter be taken up on 28th of August. On that day, if nobody represents the petitioners, then necessary order shall be passed.
Much obliged.
Much.
এগুলো কি old matter গুলো নাকি না old matter না এটা 25 তো
Item number 4.
My lord, item number 4, I represent the petitioner. My lord, I'm sorry to be appearing online. I should have been physically. my lord, on the last occasion, a direction was given, my lord, upon the state respondents to file their affidavit in opposition. My lord, we haven't been served with anything till date. My lord, there was a direction given last year, and thereafter another opportunity was given, my lord, on the 17th of July. But, my lord, till date, nothing has been served upon us. And, my lord, if they do not wish to, my lord, file their affidavit in opposition, my lord, we could proceed with the hearing.
Mr. Lakhani, on the 17th of July, the petitioner was not represented.
Yes, my lord, we had, my lord, inadvertently missed the matter. But, my lord, we saw that your lordship was, my lord, pleased to grant, my lord, the
Today-
state another opportunity to file their.
Today the respondents are not being represented.
My lord, may I
Uh,
then, my lord, may I then pray? My lord, if your lordship may, my lord, if your lordship deems fit, my lord, your lordship may, my lord, give, my lord, an extension of time, my lord, in a peremptory manner. And, my lord, we'll serve a copy of that order upon the respondents.
Let the time period for filing affidavit in opposition be extended for a fortnight, and in the meantime you intimate the your adversary that the matter will
Yes,
appear.
my lord, my only request is, my lord, if your lordship can make the direction peremptory, because this is the third extension, my lord, that they are getting.
Third time it is being extended.
My
Third
lord,
time
first they were given an opportunity last. My lord, first they were given an opportunity, my lord, on the day of the hearing, my lord, when we got an interim order, my lord, which was last year. Then thereafter, my lord, they were given an opportunity on the 17th of July. Although, my lord, the first opportunity said 2 weeks. For almost a year, they did not file. Now, my lord, on the 17th of July, my lord, they were given a chance. Nothing has been served upon us yet.
let a last opportunity be given.
Very well.
কেউ আছে নাকি এটাতে রেসপন্ডেন্ট হয়ে একজনই আছে the petitioners are being represented, but none is representing the respondents. Full stop. On the last occasion, the learned counsel representing the respondents number 2 to 4 had submitted that they intend to file an affidavit in opposition, and as such they intend to file an affidavit in opposition, and as such had prayed for 3 weeks. Full stop. Paragraph. The said 3 weeks have passed by. Today the respondents number 2 to 4 are neither being represented nor any affidavit in opposition has been filed. Full stop. Paragraph. For the ends of justice, the period for filing affidavit in opposition is extended for a fortnight. Let the matter appear on fortnight হলে আজ কত আজকে 19 তাই তো তাহলে 26/2. Let the matter appear on 9th of September. Full stop. The petitioners are directed to intimate the respondents as to the next date, and to file an affidavit in this regard.
We will do.
Item number 5.
Well, I have the petition in this matter, my lord.
My lord, I'm
Here, what happened,
my lord, I'm for the
The-
OP number 7.
he has no role at this stage, my lord. Well, here what happened, my lord, I have the land, which is my
You are representing?
I'm for the BCCL.
BCCL, my lord, the answering respondent. Now here what happened, my lord, if you lordships kindly come to my prayer first, my lord. First, I have sought for the cancellation.
একটু হালকা করে।
May I place the fact first, my lord? Thereafter, my lord, I will come.
Place
to
the
play.
fact first, thereafter the.
What happened, my lord?
অল্প আস্তে
I have, my lord, the land in my name
Hmm.
of 0.75 acre.
Hmm. In the
I
name
have-
of the petitioner.
Yes, in favor of the petitioner. That is at page, where your lordship will find the LR record, page 19. There is no dispute that I am not the owner. It is not under dispute. Now, my lord, here I have categorically stated in my representation at page 21 in plot number and area wise plot number and 0.75 acre. If your lordship will
Yes,
find
total 0.74 acres.
0.75 acre. Now, the fact is, here, my lord, this land has been taken over by BCCL without any due process of law. What is the due process of law? Either acquisition by way of Land Acquisition Act. There are two acts in the land acquisitions. One is State Act, one is Central Act of, my lord, the Coal Mines Acquisition and Requisitions Act. Or alternatively, they have to purchase the land. Now, neither they have acquired my land, nor they have purchased my land. In the, my lord, coal company, there is a rule that if a person is having 2 acre of land, he is entitled for employment.
Hmm.
Now,
Minimum of 2 acres.
minimum 2 acres is land. If a person is having minimum 2 acres of land, he is entitled for employment. Now, my brother has been given employment taking into consideration of my land, which is not permissible under the law, because I have not transferred my right. Not they have acquired, not they have purchased. My point is, let they purchase the land with the negotiation of the petitioner. Or, my lord, let they release my land and restore it in its own position. Now, if you also kindly see the affidavit filed by the Coal India, the BCCL, that is the answering respondent against, my lord, whom I have sought.
Actually, affidavit filed with. Yes, you are referring to.
Yes, my lord, I am referring their paragraphs. But page 8, this is the affidavit affirmed on, dated, date is not, has not been mentioned.
19th of September 2025.
No, August 2025. 28th August is a notarized affidavit affirmed by Kumar Sarat Sinha.
No. Affidavit in opposition from Kumar Haq. Yes, yes. Yes, August 2025.
2025.
You are referring to which paragraph?
Paragraph 11, page 8.
Yes.
You'll also will find the 1, 2, 3, 4, 5, 6, 7, 8. 9 line from top of paragraph 11.
Hmm.
The respondent number 7, namely Devabodho Majhi, will also find, my lord.
Yes.
He is my brother. But the said land is agreemented land, and till date the registration has not been done.
You are representing Debabrata Majhi.
Yes.
Yes.
Now, kindly see, my lord.
Saying or no?
The said land is agreemented land, and till date the registration has not been done by the management of Bharat Coking Coal Limited, for the very reason that the proper documents have not been provided by the landowner despite several requests, and automatically by way of inheritance the land as claimed by the writ petitioner measuring about 0.74 acres in Mouja Lal Bazar may probably mutated in the name of the writ petitioner as well as the said private respondent number 7, namely Devabodho Majhi. So, my lord, these 2 acres of land has been divided in 2 parts. One part recorded in the name of the writ petitioner, one part has been recorded in the name of the respondent number 7. So there is a no 2 acres of land as of now. So first thing, my lord, let the, my lord, take over my land with due process of law until,
Or
or my lord, let the purchase, my lord. I am agreeable to sell if they, my lord, provide, my lord, the present market rate with others benefits. Otherwise, my lord, why I should suffer? This is their stand in their affidavit. Or, my lord, the employment, as has been, my lord, provided to the respondent number 7, be stopped till he qualifies the 2 acres of land. They cannot. That's why I have also made CBI to the party to the proceedings. Because this is the, my lord, highest example of, my lord, the, my lord, fraud committed by the respondent number 7 in collision with the, my lord, officials of the respondent number, my lord, 1 and 2. CBI party আছে না? Party nahi? No, my lord, I have made complaint. No, sorry, my lord, I have not made party, but I have made complaint, which is possibly I have annexed in my writ application. করেছিস না করিস নি annexed পরে হয়েছে না?
who has not
Well,
been made a party?
No, I have not made party, but subsequently I have made complaint to the CBI.
Who has not been made the party? Who has not been made a party?
Well, CBI. Well, CBI, I made complaint before the CBI for registration of the appropriate case against the official of the Bharat Coking Coal Limited as well as, my lord, the private respondents. Because land loser schemes specifically says 2 acre land is required for the purpose of employment. Admittedly, there is no 2 acres of land.
There is 0.74 acres of land.
0.7 for if it is DTAC,
That too, you are claiming to be in your name.
it is already in my name, but they are using forcefully. How they can?
And half of that land, the ownership of in respect of half of that land.
Yes, in the name of
in the
respondent
name
number
of
7.
respondent number 7.
So there is a less of 2 acres of land.
0.37 belongs to you, and 0.37 acres of land belongs to you, the respondent number 7. That is
Yes,
your brother.
my lord. Almost 50-50. So, my lord, they cannot continue the employment. First prayer.
Full-blooded brother.
My lord,
Full-blooded brother.
full-blooded brother. Because they have created the problem. There is another land. My lord, as to why I am telling, my lord, your lordship's mind is playing. I have also asked my client as to why you are doing all these things. Main thing is, my lord, there is another lands for providing employment to the son of the writ petitioner.
Learned counsel,
My lord,
in whose name originally the land was?
father, ancestral property.
Ancestral property. There is no dispute as regards to that.
No, there is no dispute.
So-
And I have annexed the LR record.
Apart from both of you, is there any other legal heir of your father?
No. So now, my lord, problem is they have created the private respondent number 7. There is another land for getting employment in favor of, well, there was a, my lord, verbal settlement that you use this land, and whenever the turn of my son will come, you give no objection to that land. So now he is not agree to give the no objection in his part. So let there be, my lord, my lord, decided that whether he is, my lord, entitled for employment, and whether BCCL can continue his employment, and whether BCCL can use the land without any due process of law.
Learned counsel, what are your prayers?
My lord,
Place the prayers.
first thing, my lord, cancellation of the employment of the private respondent.
So cancel the employment of the private respondent.
Yes.
So
First,
he is also one of the answering respondents.
yes. Now, my lord,
Not that he is not an answering respondent. He is one of the answering respondents.
answer respondent, but my lord, ultimately the answer will be provided, my lord, by the
Steps will have to be taken by BCCL.
yes, well, they have already stated in their affidavit.
Yes,
Now, my lord,
second prayer.
Written in the nature of mandamus do issue commending the responsible authorities to provide payment of compensation and land value at par with the present market rate, and to pay the profit for extracting the coal unlawfully from the land measuring about such and such, both together with 18% interest. In the above alternative, restore the land to its, if it is not agreeable by them. In the alternative, restore the land to its original nature and character prior to the unauthorized utilization. Pay the rent on the same from the date of use till the date of payment is made, along with an undertaking to cease further use and refrain from disturbing the petitioner's peaceful enjoyment, forthwith cease all mining or other commercial activities on the said land forthwith. And also I have paid for 10 lakhs of compensation for harassment and unauthorized use of the land. Now, my lord, I will show to your lordships the affidavit filed by the private respondent. Can you see page 21?
Yes.
This is the reminder number 1. This letter was issued by the coal company to the, my lord, private respondent. You have been appointed against your land on agreement conditional basis in the year 1996, but till date you have not registered the land in favor of the BCCL, based on which your employment has been provided. You are requested to submit the copy of the appointment letter and other relevant documents for your employment, along with proof of ownership of the lands, plot-wise, quantum of lands involved in your employment. Non-submission of the aforesaid documents may lead to disciplinary actions as deemed fit in this regards. A similar letter such and such had been given to your concerned project officer in this matter, copy enclosed. So they are also in the same view. The registration has to be done. This is a letter of 2024. Series of letter has been, but till date, my lord, he could not register the land in favor of the employer. And it is very surprising as to how, my lord, the employer is allowing this kind of, my lord, high risky, my lord, job where there is no land in the name. When they have also sought for the registration, they did not. When I have filed the writ application, even then they are supporting. So that's why I have prayed for, my lord, I have wrote a letter to the CBI for investigation against the chairman of the BCCL and all officials.
Anything more?
No, my lord, I will reply, my lord.
Yes. Learned
Actually,
counsel.
my senior is involved in 237 courtroom member. So I am praying for not today.
Short pass over now. আমি তো রেগুলার আসি না এখন।
Is your lordship?
Well, let my learned friend start till then, my lord. Let him, my lord, short pass over
No.
because you have heard.
He will have to respond first. Thereafter, they will have to give the means in sort of a reply in respect of the combined submission. First of all, I thought that his submission is not required. That's why I proceeded.
Let it fix
Actually, everything is before your lordships.
because my
Their affidavit, his affidavit. He also, my lord, annexed the document. He also annexed the document.
When can your learned senior come? When can your learned senior come and apprise the court? When?
Maybe
শুনুন, let it be passed over.
My lord. My lord. ডাকো তাড়াতাড়ি, ওই যে সব ডাকছে।
fix another date.
কেন রে ভাই? আমি আসি না রেগুলার বলে নাকি?
That's why I have matter.
Since I am not regular, he is taking advantage. His matter is running since long in the list.
If the matter is likely to be taken up, lordship,
He likely to
I think
take.
this matter will be.
So why you have not sought for the time at the initial stage? You are
No.
taking advantage.
Why? There is no question of because my lord, it posted passover. That is, it made difficulty. Code number 4, that matter may be called on at the relevant point of time. This is the first foot or
Let
item.
me pass over, my lord. Let my learned friend
Lord,
come.
sir. Otherwise,
Let my learned friend come.
otherwise, lordship.
Let my learned friend come.
Let it be fixed on Friday.
I never paid for any
2
adjournment in this matter.
2 p.m.
No.
The
2 p.m.,
tomorrow.
Tomorrow we don't have the
Let my lord.
original.
Let my lord matter be, my lord,
Next
my lord be passed over. Let my learned friend, my lord, finish. If my lord he required, then my lord, your lordship may, my lord.
Lordship, I have fairly submitted, lordship. My matter may be taken up, lordship. One matter is going on in code number 40, lordship.
Let it appear on 28th at the top. ঠিক আছে? 28th at the top. Learned counsel. On that day, don't seek anything, whether adjournment or passover. Don't seek that.
20th, my lord, at 10:30.
28th, yes, at 10:30.
Kindly, my lord, pass, my lord, online order, my lord.
The learned counsel representing the petitioner submits that the respondent, the Bharat Coking Coal Limited has taken over possession of 0.74 acres of land belonging to the petitioner and the respondent number 7, namely Debobroto Maji, M-A-J-I, Maji, in equal proportion. Full stop. He has further submitted that neither any compensation in respect of the said land has been provided to the petitioner, nor the said respondent number 1 has purchased the said land. Instead, the respondent number 7, namely, the respondent number 7 has been provided with appointment, but the petitioner has not been provided anything. Full stop. The Learned Counsel further submits that at least 2 acres of land are required to be handed over to the Bharat Coking Coal Limited as per the provisions, but having less quantum of property, the respondent number 7 has been given appointment. Full stop. In such circumstance, the petitioner prays for either the Bharat Coking Coal Limited acquired the said land by providing appropriate compensation according to the present valuation of the land, or to purchase it. In the alternative, to provide appointment to the petitioner. Full stop. Paragraph. After the completion of the submission of the Learned Counsel representing the petitioner, the Learned Advocate representing the respondent number 7, who is to respond, seeks an accommodation. Accordingly, let the matter appear on 28th of August.
If I were to pick 27th, 28th is Rakhi. Then thereafter 4th is also holidays.
We have original site on Wednesdays and Fridays.
So 26th is Wednesday, my lord.
26th.
Wednesday.
Holiday, perhaps holiday.
26th.
Yes.
Is it?
Yes, 26 holiday.
So
Then 9th.
second is
Yes,
Wednesday.
second is fine, my lord.
Let the matter appear on 2nd of September. On consent of all the sites, let the matter appear on 2nd of September at the top.
At 10:30, my lord.
At the top means
Here also sits in, my lord. First of
first of all,
Very
the original site matters are taken up.
Very well.
2nd of September.
My lord. Good.
এই ফাইলটা না এই ফাইলটা একবার সময় করে দিয়ে দেবেন তো এই ফাইলটা দেখে আসো তাহলে সুবিধা হবে।
Item number 6. Item number 6, my lord. The lordship kindly remember, my lord, the last 3 occasions they did not appear, my lord. I have filed my affidavit in opposition and no reply has been filed. Because, my lord, they are not interested, initially challenging the tender notice, my lord, no order was passed. Subsequently, they preferred an appeal, my lord.
Affidavit in opposition কোথায় আছে? আছে? ওখানে আছে।
Opposition filed, my lord. Filed on, my lord, 17 July 2026.
Mm, Respondent to none is representing the petitioner, none is representing the petitioners, yeah. Last chance.
My lord, last and last occasion, your lordship given last year, because my lord, your lordship kindly, I appreciate, nothing remains in this writ petition, my lord. Nothing remains, because the tender was issued long time back, thereafter, my lord, the goods has been sold. And subsequently, they preferred an appeal was dismissed.
Nini. The wide order dated 24th of July 2026. It was last chance was provided to the petitioners, but in spite of that, none is representing virtual mode নেই তো? But in spite of the earlier direction, none is representing the petitioners. In such circumstance, the matter is dismissed for non-prosecution.
Second one is the same thing, my lord, same appeal, same direction. 28th, 17th. Lordship kindly see 17th order and 20th order.
এটাতে আগে একটা লিখে দেবেন যে on 17th of July 2026 the petitioner হলে মানে এটা 6th একই সেম অর্ডার হবে, ঠিক আছে? তাহলে ওটাতেও যদ্দূর মধ্যে 17 জুলাই none had represented the petitioner বা petitioners, দেখে নেবেন petitioner না petitioners, ওটা দেখে নেবেন। আর on 24th of July none had represented the petitioner. 17th of July none had represented the petitioner, while on 24th of July also none had represented the petitioner. As such, for the ends of justice, the matter was kept today as last chance. Full stop. Today also, none is representing the petitioner.
Dismissed, my lord.
Dismissed. No, it's the choice hole. 5 or 6. 5 or 6. ঠিক করে নিন। 6 or 7. ও তো তাহলে 7টা দিন। 7টা রাখুন।
Item number 7.
7, হ্যাঁ ঠিক আছে, 6 or 7, ঠিক আছে?
এইটাই নামটা দিয়ে দেয়। 7, 7, 6. Item number 8.
My Lordship, for item number 8, I am for the Transport Corporation. My Lordship, I am praying for accommodation on the ground. My Lordship, yesterday in our office premises, there was an fire incident. There was a fire incident, my Lordship. So the building is sealed by the concerned authorities. So we don't have the brief with us. So I'm praying for at least 2 weeks time, my Lordship. Transport Corporation.
You are representing 1 to 5.
My
Respondent.
Lordship, I don't have the brief with me, but I am for the Transport Corporation, my Lordship.
My lord, I am appearing on behalf of state, my lord. I have to file opposition, my lord. My lord, 2 weeks times to file opposition, my lord, please. Led by Mr. Saurabh Sengupta.
Who is representing the writ petitioner? Who is representing the writ petitioner? None. None is representing. Have you been served with the copy of the writ?
No, my lord, I was not. My lord, the order of lordship is of 24th of July.
24th of July.
My lord, I had to write to them, and they, my lord, served me on 5th of August.
So
Only after I wrote.
Ultimately, it has been served.
Sir, lordship, I have already asked for instructions. Lordship, kindly extend the time to file the AO by the state, my lord. By 2 weeks, I'll come back.
The learned counsel representing the state seeks further accommodation, seeks an accommodation for 2 weeks to file affidavit in opposition. Full stop. Paragraph. The learned learned advocate representing the Transport Corporation Limited. That is the respondents number 225. Seeks an accommodation for a fortnight on the ground that some untoward incident took place in the said office yesterday. Bracketed fire broke out.
Yes, my lordship.
Bracketed fire broke out. ঠিক আছে 2 weeks বলেছি the learned counsel learned counsel representing the state ঠিক আছে further submits that as per the direction dated 24th of July 2026, copy of the writ petition was not initially served, but after a letter being written to the learned counsel representing the petitioners, a copy of the writ application has been ultimately served on 5th of August 2026. তারপরে লিখে দেবেন in such circumstance he seeks an accommodation for a fortnight to file affidavit in opposition. None is representing the petitioners today. Full stop. Paragraph. Consider the submission of the learned counsels. Accordingly, the matter is adjourned to 2 weeks. 2 তারিখ খোলা আছে second of September.
As well, lordship.
2nd of September for filing affidavit in opposition. Thereafter, if they intend, then opportunity will be granted to them.
Absolutely. Deeply obliged.
2nd of September.
Number 9. I am appearing for Union of India. Respondent number 1.
My lord, I'm appearing for the petitioner. My lord, on the last occasion, there was a direction on me to serve notice. However, I could not get a hold on respondent number, counsel of the respondent number 1. My lord, I'm only praying for 1 week's time. I shall serve and come back.
You have not received, learned counsel, you have not received copy of the writ.
We are for respondent number 1 only, my. Whether they have served upon other respondents, I do not know.
So she is submitting that she could not get hold of the learned counsel representing the respondent number 1. Respondent number 1 is the Union of India.
Yes, my lord, I just met him today. I'll serve and I'll come back.
And you are representing the remaining respondents?
No, both of us are for the same.
Hi. What about the
answering respondent is my lord. Answering respondent.
We are not the principal. Principal respondents 5 and 6.
One can submit, not both of you.
Principal respondent is 5 and 6, man. Their GST registration was cancelled, my lord, because they did not reply the so cause notice.
Has it been served upon the
Yes, my lord.
central GST?
Yes, my lord.
Served. Why are you seeking accommodation?
My lord, my advocate on record is not in town. So
That you say. Mm, uh, the Union of India, the Union, the advocate representing the petitioner seeks an accommodation on the ground of the learned advocate on record. Full stop. Paragraph. Representing the petitioner বলেইছি accommodation on the ground of the learned advocate on record. তার মানে petitioner the learned counsel representing the Union of India submits that the answering respondent is the central GST and CX, capital C, capital X. 5 is Superintendent CGST and CX Kolkata, Appeal 2 Commissionerate. And 6 is Superintendent CGST and CX Range 4, Bali 1. Last sentence. Union of India submits that the answering respondents are the respondent number 5, Central GST and CX. That is the respondents number 5 and 6. Full stop. None is full stop. None is representing the said respondents. On the earlier occasion also, none had represented the said respondents number 5 and 6. Full stop. Consider the submission of the learned counsels. The prayer seeking accommodation is allowed. Let the matter appear on সামনের বুধবার কি আছে? সামনের বুধবার হচ্ছে 26 ছুটি 28th.
Item number 10. Lord, I'm querying for the respondent. Item number 10.
For the petitioner, I want to file a supplementary affidavit regarding new section 147 of the amendment.
Lord, your Lordship will kindly see your Lordship's earlier order, Lord, 7th August 2026, my Lord. Very your Lordship. Lord, he wants further extension of time. Lord, Lordship can, because in that case, Lord, there's an amendment in section 147A, your Lordship knows, Lord.
147A.
Yes. So he wants to file a supplementary affidavit.
Why aren't you sought for fortnight?
Somehow,
You could have sought for more time.
And Lord, once we get the supplementary affidavit, we will also file our opposition within 4 weeks, my Lord. So
has the argument started in the Bombay High Court?
No. It has been started. It's not been completed, my Lord. Matter is going on. So that's why, my Lord, we have shown a letter to your Lordship, my Lord, that we don't want, my Lord, these matters to be clubbed together. And,
it is expected to be.
My Lord, by next month, my Lord, I think. Because the Supreme Court has said the entire exercise has to be done within 30th September 2026. That was preferably the Supreme Court has said, not that matter.
The learned counsel representing the petitioner seeks an extension of the time. Seeks an extension for a fortnight to file affidavit, supplementary affidavit. Full stop. The prayer is considered and allowed. Let the matter appear on September 9th of September.
9th of September.
9th of September.
Item number 11.
Well, I am with the petition in this matter, my lord. This matter is covered by your lordship's division bench judgment. The matters relates to my lord, the monetary compensation in lieu of employment. Here, my lord, in 1998, husband has died. Thereafter, employment was sought for. They have consumed my lord, a lot of years, but till date, neither employment nor my lord, monetary compensation in lieu of employment has been provided.
You are representing ECL.
Yes, he is
Ms. Tanushree Dasgupta is appearing for the ECL.
Hmm.
She's on her legs, Your Lordship.
Last day, my lord, your lordship, my lord, recorded is a last chance, and every day, my lord, they are
Your Lordship, kindly grants me.
taking my lord time.
Grants me, grants me for 5 minutes pass over, Your Lordship.
You do not intend to file any affidavit in reply.
No, it's not required, my lord.
They
It is
not
a simple
required.
matter, my lord. They have served me copy of the opposition. Though I have filed my lord reply in respect of the report filed by them, so same thing they have my lord repeated. So my reply file in the my lord report be treated as my lord my stand.
The report has been filed by you.
No report. Initially there was a my lord, direction to file report. They have filed the report, and I have filed exception.
You have not filed. You have not filed any affidavit in opposition.
So there is the last chance, my lord, your lordship recorded.
Your Lordship, Ms. Tanushree Dasgupta is, I think so. She's carrying the affidavit of opposition. Kindly grants me 5 minutes pass over. She's coming in.
Very good. No, may I start, my lord? No.
Lord Counsel, do you intend to file the affidavit in opposition?
Opposition is ready, Your Lordship.
Copy has been served.
Copy has been served.
The affidavit in opposition has been filed on behalf of the ECL, Eastern Coalfields Limited, after serving copy of the same upon the learned counsel representing the petitioner. Let the affidavit in opposition be kept with the record. Yes.
Page 31A, you will find. I have given my lord the type copy of the death certificate in 11 December 1998. The husband has died. Now, thereafter, my lord, immediately I made application for employment. So that copy is not presently traceable, but they have replied. If you will kindly come, page 32. Further to this later data.
What type of death certificate this is?
My lord,
issued by whom?
Issued by the Eastern Coalfield itself, because he died in the hospital of Eastern Coalfield. Page 31, you will still find.
Signed it in page 31A.
No, 31 is the mother copy. You will also find. There is no dispute, my lord. They have issued the death certificate by them. There is no dispute.
There is no dispute as regards to the death certificate. Learned counsel.
Lordship, death certificate is not the question of dispute.
Page 31, then 31A. Now, my lord, kindly come page 32. 32 is, my lord, the answer given by them, response. Now, in 1998, my lord, I have immediately after that death, I made application for employment, though that copy is not presently traceable. Now, you'll also find from page 32.
Deepak Bowri has expired on 11th of October 2019.
11th of December 1998. 11th December 1998. In the hospital of Eastern Coalfield Limited.
Place the page 31A. That is the death certificate.
Certified that is Deepak Bowri of 29 years age, son of late Subdev Bhuiya. Subdev Bowri working at BHD Colliery. BHD Colliery. I am reading from the mother one. BHD Colliery and residing at Majgachia, village Ithora, post Konnapur, PS Salanpur, district Bardhaman, was suffering chronic leukemia since 1996 and was admitted in company's hospital at tropical medicine. Now thereafter admitted and subsequently of tropical medicine at Kolkata, followed up with a blood test. He expired on 11th October 1998.
And then that too in page 31A, it is mentioned that 11th October 2019.
No, it's wrongly written, my lord.
No,
They are in their
the
opposition.
exact-
In their, they have this date, date of
Counsel,
death.
from the page 30, the actual fact will reveal.
Yes.
Certificate of death in respect of Deepak Bauri. Date
Deepak
of
Bauri.
death 11th October 1998.
My lord.
So he has expired on 11th October 1998.
1998.
Yes.
Now, my lord, thereafter I made application for employment. Now they have responded at page 32. Kindly come. Further to this letter number such and such of such and such dated such and such 2010, wherein directed you to submit indemnity bond from the Court of Executive Magistrate Asansol duly registered and fresh relationship certificate, no objection certificate outside death formality, etc. But till date you have not been submitted. The same as your claim for employment file could not be processed. You are once again directed to submit the same immediately. Thereafter, my lord, I have submitted everything to them. Then they sent me in 2011 before the screening committee. Kindly see subject, screening of employment process.
Page
33.
Yes.
I have given type copy. Screening of employment process.
Yes.
They have started to screen the entire thing. Thereafter, my lord, kindly come page 34. They directed me to produce the original death certificate and submit death registration certificate of the deceased and certificate from the Pradhan MLA clarifying her difference of a photograph such and such. These are not relevant. Thereafter, my lord, my lord, wrote letter 2012 an appeal for a such and such of a husband late submission of the death certificate and etc. I have, my lord, submitted. Thereafter, my lord,
ultimately submitted on
my lord, February 2012.
February 2012.
Death registration.
Yes. From which page it will reveal?
My lord, 35, as per your letter number such and such, I would like to inform you that already I have applied to ADM Asansol for collecting the death registration certificate of my late husband. But sorry to say, it is very lengthy process and difficult and hasty to collect that certificate. In this regard, in these hard days, I am maintaining my big family and days by so, my lord, they have expressed his, my lord, difficulties before them.
No, the question is when you have lastly submitted all the documents.
Well, they have responded, my lord. Subsequently, since, my lord, I have completed, the next page, your lords will find, though that date is not specifically mentioned anywhere, my lord. It is lying in their office, but these are not the dispute.
The 11/9/2013 or 15, you were requested to be present before the area screening committee.
13.
Page 36.
Page 13. 6 September 2013. You are requested to please advise the following.
2013.
Before the screening committee, which will be held. So, my lord, I have deposited everything. That's why they have, my lord, further asked me to appear before the screening committee, along with family member, witness, original death certificate. Again, they have sought because they are to show, my lord, death registration certificate of the witness, such and such, service record. So, 5 persons were called, including the rich petitioners.
Yes.
Then, my lord, another screening they have conducted in September. Page 37.
11th of September 2013.
13. Thereafter, my lord, 38. In December 2013, they sent me before the medical examination. Page 38.
Yes.
You are requested to kindly examine the following audiometry test, which they will be subjected to initial pre-employment medical examination and getting the reports. Kindly see page 38.
Yes.
They have sent me before the medical exam. This is the pre-employment. This is the last stage to provide the employment. Thereafter, another employment they have conducted.
Mr. Ghosh, have you provided list of dates?
Well, list of date I had at my lord, petition at top, my lord, I have given. Short and my lord, big. I'll show to you also the list of dates. Finally, let me complete my annexures, my lord. Now, my lord, page 40 onwards, there is no dispute, my lord, with regard to the claim, and they have processed. Thereafter, my lord, the letters. Thereafter, page 42, you will also come. In 2024, after a long lapse of time, in 2024, we have submitted employment claim against your deceased husband as per instruction by the higher authority. A 3-man committee report is required to verify the relationship and where about the deceased family. You are advised to attend our office. So I have attended, and they have, my lord, made recommendation in my favor. And accordingly, my lord, they placed my file in their final stage, page 43. You also will find the status of employment under National Coal Wage Agreement up to January 2023. কোথায় আছে ওটা? ED নম্বরটা কোথায় মার্ক করে?
Wherein your name appears?
My lord. Page 46, my lord.
1 minute.
Page 46, second from top. Let Deepak Bauri, LRC, fine, my lord.
46. Yes, the late Deepak Bauri.
Deepak Bauri, BHD Kolyari, Sodhpur. Name of the claimant is Anna Bauri. The
Anna
petitioner
Bauri.
before your lordship's wife. Then, my lord, kindly see processed.
Processed. Yes.
So thereafter, my lord, they did nothing, my lord. So since a considerable time has already been elapsed, at this stage, my lord, employment is not feasible because I have also, my lord, reached the age of 50 years.
So you cannot be provided appointment now.
I am not asking for appointment. If they can, my lord, I am agreeable if they can, my lord, from retrospective effect. Because due to their latches, they have not provided. Now, if your lordships kindly see the prayer. I have paid, my lord, the employment, the monetary compensation from the date of death with 18% interest. Till she attained the age of 60 years. And I've also prayed for the independent medical board since I don't have any document to show my date of birth. All he sees illiterate, my lord.
Till she attains the age of 60 years.
60 years. So, paragraph the B, prayer B is for medical examination to assess the date of birth.
Yes.
Now, your lordship's judgment. These are the fact. Your lordship may remember all those judgments, my lord, sitting with my lord Justice Talukdar. All have been, my lord, went out to Supreme Court and, my lord, affirmed.
Provide the relevant one.
I have lot, my lord. I will show to your lordship 1 and 2. I will show to 1 because it's stitched with. I will show 1 and 2, my lord. Your lordship's judgment I will show. Let me, my lord, see the, my lord, name of the judge. Honorable judges, my lord. Page 1, my lord.
The Eastern Coalfields versus Srimati Panwa Bhuiya.
Yes.
1 to 9.
Your lordship has delivered judgment. Same point. There are a lot of judgment delivered by your lordship. Page 1, my lord, in handwritten.
Yes. Yes. relevant portion.
Same fact, my lord, relevant portion, my lord, kindly see, my lord, the paragraph 9.
The fact is same. Which
Fact
was
is
in,
same, employment was sought for, they have not provided, your lordship directed the,
ultimately, the spouse was not provided with the employment and she had attained 50 years, more than 50
more
years.
than 50 years.
So the relevant paragraph?
Paragraph 9.
9.
Hmm.
Gotcha. Yes.
The learned counsel appearing on behalf of the appellants during exhaustive argument has submitted that the scheme of compulsory appointment is not a vested right inherited by the writ petitioners, and the same cannot be equated with the right of pension. The learned counsel also submitted that initially application for compulsory appointment was made by the writ petitioners, and after the first screening of the application for compulsory appointment, the contradictions regarding the age of the writ petitioners was pointed out to the appellant. He has further submitted that there are contradictions between the information provided by the ex-employee and the declarations made by the writ petitioner. He has further submitted that decisions for employment in lieu of MMCC was confirmed by the writ petitioners. Once again, in 2016, he further submitted that on Atto, the writ petitions had declined to accept MMCC. He has further submitted that on 2017, appointment on compensation ground was regretted because of discrepancy and explanations of facts. The learned counsel submitted that on 2018, the application for MMCC was made by the writ petitioner, and accordingly, proposal from MMCC was initiated. He has further submitted that there were several discrepancies as regards the legal year certificate and the police verification report. The learned counsel also submitted that there is a contradiction as regards to the writ petitioner's age. In support of his contradictions, he has submitted that in the affidavit affirmation, the writ petitioner's age reflected 35 years, while on the same date an indemnity bond was submitted by the writ petitioner wherein her age was mentioned 42 years. In addition, in affidavit affirmation 2011, the writ petitioner had declared her age to be 46 years. The learned counsel appearing on behalf of the appellants hence submitted the contract considering the aforesaid factual circumstances, the ECL cannot be held to be liable for delay on coming to the conclusions as to the whether compensation appointment will be given to, or MMCC will be paid. Relying on the aforesaid facts and circumstances, the counsel appearing on the respondent appellant submits that the honorable single judge has not come to the correct conclusions which ought to have been done. As such, he prays for setting aside the order passed by the honorable single judge. Now, your lordship's my lord held is a beneficial legislation. And finally, page 8, after considering all aspects, the honorable single judge has come to the finding that it previously entered to MMCC as per the provisions of National Coal Wage Agreement from the date of succeeding the death of her husband, that is on 25th May 2012, and has also stated that it petitioners will be entitled to regular monthly payment within 10th of each month. This court is also of the view that respondent is entitled to MMCC from the succeeding death of her husband. As such, this court finds no reasons to interfere with the impugn order. So thereafter, my lord, preferred SLP page 10. SLP has been dismissed with a liberty to them to comply within 2 weeks. Only time extension was given by the Honorable Supreme Court. Another judgment, all are in the same line with my Lord Justice Talukdar and Lopita Banerjee as their lordships then was. Page 28. There are other judgment with the other another honorable judges. Page 20 is also delivered by your lordships, possibly. Yes. Chapola Kora.
In the judgment of, what is the name of the petitioner?
Panwa.
Panwa Bhuiya. There was discrepancy as regards to the age. Herein.
No, there is no discrepancy. I have prayed for a medical, either in their board or outside. Your lordships may decide.
Herein, medical examination has not taken place as yet.
No.
So her age has not been determined.
Let that determine or outside, my lord, whatever your lordships may feel, my lord. Regarding age, they have also not raised anything. Page 28.
Yes, page 28. That is
here also the judgment delivered by your lordships. Same fact, almost same fact. Issue is same. Paragraph 6, your lordship will find sixth line from bottom of paragraph 6. The Learned Council has further submitted that writ petitioner was pursuing compassionate employment for her son and had not applied for compassionate employment for herself, nor did the writ petitioner opted for MMCC at the first instance. He had submitted that the recourse sought for has been made at a belated stage and has further submitted that the ECL by no stage of imagination can be held liable, responsible for the delay or non-action and oblique or non-compliance for the processing her son's employment. He has further submitted that the writ petitioners had accepted the proposal for compensation appointment and had never objected or denied the appointment of her dependent son. He has further submitted that the Honorable Judge has passed the order of payment under the MMCC in spite of the fact that the writ petitioner has all along pursued for compensation appointment. The Learned Council has also submitted that the ECL cannot be held responsible for the delay, non-action, non-compliance for indirection. The Learned Council has further submitted that the ECL has been burdened by a directions to pay of huge area. Learned Council has also submitted that the petitioner, once having applied for employment of his son on compensation ground, he waived her right to claim MMCC. The Learned Council have further submitted that writ petitioners came up with a prayer in the writ petitions after more than 16 years of death of her husband, as such the prayer of the writ petitioner being made at such a belated stage ought not to have been accepted considering the aforesaid facts and circumstances. The Council has prayed for allowing the instant appeal. Now, my lord, ordering portion. The page 35.
MMCC is receivable by the family of the deceased from the date of death
Yes.
of the employee, which has been time and again highlighted by this honorable court. In this regard, this court cites the measure.
Devanti
Kumari.
Yes, celebrated judgment. Your lordship's directed with interest 6%. If from the above direction it is apparent that the MMCC is to pay to writ petitioner from the date of death of employee, as such the order of the single judge directing the ECL to pay MMCC writ petitions from such and such being the date of death of Sagokora, the employee, along with arrear at the prevailing rate from time to time as per NCWA between such and such with interest at 6% per annum is in accordance with the law, as the writ petitioner is entitled to receive MMCC from the date of death of her husband, who was an employee till the attained the age of 60 years.
Rate of interest is 6%. Rate of interest
6%. Now the Honorable Supreme Court enhanced it 9% in my matter in the monetary compensation. Rate of interest, my lord, I will my lord, leave it to your lordship. Now they have preferred a SLP, page 640.
Page
440.
Yes.
SLP dismissed. All these judgment I have, my lord.
So you are referring to these two.
I can, my lord, but it's not, I think it's not necessary. With all the judgment on the same point. Even Honorable Supreme Court, may I show the latest Supreme Court judgment in monetary compensation? Not latest, but this judgment was not placed in the before the Honorable Division Bench. Page 319, if you lordships kindly see.
319.
This is a Division Bench judgment. I will show to that judgment also. This is Division Bench judgment of Madam Justice Bosak.
Yes.
Kindly see the only last paragraph. page 45, paragraph 45,
1 minute.
page 2, 3, 3 to 9.
Yes. Page 3 to 9.
Kindly see the paragraph 45. Even the special bench of this honorable court also held
Yes.
now page 63, if your lordships kindly come. This is the judgment of honorable Supreme Court.
Subhadra.
Subhadra. Subhadra, the Supreme Court judgment, your lordship will find from paragraph 3.
Yes.
It is the stand of the respondent organization. They were prepared to grant monetary compensation 3,000 per month to the appellant, whereas it was appellant who insisted for employment. The learned counsel who has pointed out, therefore kindly come on a page, paragraph 5.
Yes.
The learned counsel for the respondent number 2 organizations has invited our attention to the decision in this court in a case of Canara Bank versus M. Mohesh Kumar. This judgment I will find from your lordship first time from lordship division bench judgment. I was not aware your lordship referred this judgment. The learned counsel for the respondent number 2 organizations has invited our attention to the decisions of this court in a Canara Bank versus M. Mohesh Kumar and submitted that the compensation appointment is not a matter of right and there is a discretion available to the employer. We have no quarrel with the settled positions, but the instant case is not case of discretionary compensation employment governed by any of the statutory guidelines. It is governed by the scheme as agreed by the parties and which has become the part of the bipartite agreement. The terms of agreement are very specific and give no room for any discretion. Now, kindly come on paragraph in para 9.5.0 of the agreement. It is very clear that is and is specifically mentioned that the female dependent, if the below 45 years of age, has an option either to accept monetary compensation or employment. It is not an option reserved to the employer, but it is an option given to the employee. It was the terms of the agreement only that the appellant had been insisting that she should be given employment if she is otherwise eligible in terms of the bipartite agreement. But the second respondent has kept on insisting that the son, being above the age of 12 years, would be kept on live roster until the attend of 18 years and until such time the appellant would be given compensation of 3,000 per month. Now, kindly come findings. The having regard to the entire facts and circumstances, paragraph 10, kindly come. Having regard to the entire facts and circumstances of the case, we are of the view that the interest of justice would be met and complete justice would to the appellant will be rendered in a case of the appeal is disposed of as follows. The second respondent is directed to appoint one of the son of the appellant who has otherwise become major as of now, as per the choice of the appellant within 2 months from today. Needless to say that the appointment will be commensurate with the qualification and entitlement of the incumbent. This is the first employment given. Thereafter, from 2004, as ordered by the High Court, the appellant shall be paid 3,000 per month. Monetary compensation also paid with interest at the rate of 7.5% from the respective date when the amount become due towards all other claim on account of loss of employment for the last 13 years. As far as the appellant is concerned, it would be just fair and reasonable that a lump sum amount is paid to the appellant which is fixed 5 lakhs. This amount shall also be paid to the appellant with a month of 2 months from today. So, my employment, monetary compensation, interest 7.5 from the date of death, as well as the 5 lakhs costs have been imposed because the bipartite settlement as agreed by the parties, that is the management, the employer and the trade union. It is a very specific and clear. They have to pay and they have to provide the employment. If it is fault on their part, my lord, agreement. My lord, kindly come. I have entire agreement. I have your lordships also in your lordship's judgment quoted. I have also given the agreement, the relevant portion, page 6 of the compilation.
Page 12 of the writ application.
Page 12 of the writ application. I have also in the compilation. I have entire agreement. I have the relevant agreement. I have quoted.
Page 6 of the compilation.
Page 6. 6 of my lord, the running page, not in handwritten. From the beginning of this compilation, your lordships in top will find page 6.
Page
Where the
6.
all judgments
Yes,
ends.
page 6. It commences with the employees since deceased do get a chance to overcome.
No, kindly see the tabulation of my all judgments. Last 1, 2, 3, 4, 5, 6.
Yes, the first
Last box. Kindly come to the last
box.
Yes.
Okay. Last box is item number 43.
43 thereafter. The chapter
Yes.
9 of the National Co-Lodge Agreement
Achha,
are reproduced here in below.
here in below, achha.
I have also same thing quoted in my writ application. The provision of employment to the dependent. Your lordships also in your lordship's judgment, this clause has been, my lord, referred. Hello.
Up till 43, everything is there. Thereafter, nothing is there.
My lord, in the writ application, page 12.
No.
the
No,
relevant-
the clause 9.3.0,
0.
9.3.1, it is not there in this one compilation.
No, I have quoted here.
You put it in the writ.
No, quoted in that page.
Achha, you have
After
quoted, achha.
completion of box, kindly see.
Oh, that is the crux you have quoted.
Entire provision I have quoted. Not cracks, my lord. Entire provision I have quoted.
9.3 provision of employment to
Yes,
dependent.
kindly see, my lord, chapter 9 of National Co-Lodge Agreement at, my lord, just above
Provision,
the
yes, the
reproduced
chapter
here in
9 of
below.
National Coal
Provision of employment to the dependent.
reproduced here in below. 9.3 provision of employment to
Employment
dependent.
dependent
9.3.1 employment would be provided to one dependent of workers
who
who
die.
are disabled permanently and also those who die while in service.
Yes.
The provision will be implemented as follows. 9.3.2 employment to one dependent of the worker who dies while in service.
And 9.5.0 employment monetary component, employment oblique monetary component to the female dependent. Here.
Yes. No, herein it is there.
Yes. So, my lord, your lords will find, my lord, that either, my lord, I am entitled for employment or MMCC. But in a case of delay, the Honorable Supreme Court directed that the son is to be given employment, wife is to be given, my lord, monetary compensation with interest 7.5 from the date of death, and, my lord, for all this harassment and etc., all the Honorable Supreme Court directed 5 lakhs cost.
Yes.
Lordship, this matter is slightly different from the observations that my learned friend has shown, because here, your lordship, admittedly, the employment couldn't be given, but the delay and the latches has to be ascertained on whose part. Lordship, to cut the matter short, your lordship, I can place the one relevant letter in my which I have referred in my opposition, and it is an annexure C. That is in 2021, because the employee died in 1998. Subsequently, the wife of the deceased repeatedly sought for employment. She was not qualified, screening was done. And subsequently, since she couldn't qualify for employment, on repeated occasion, we have approached the wife of the deceased to seek MMCC. Even in Annexure C, that is the letter dated 11th October 2021, there also.
You are referring to?
My opposition.
Yes, opposition, which page?
Annexure C, Lordship,
1 minute.
Annexure C. Letter dated
Yes.
11th October 2021.
2021.
Lordship may be permitted to place the same. Please refer to the office of the earlier letter dated such and such, wherein you were conveyed the opinion of ECL to submit your claim for MMCC in lieu of employment as your age about 50 years. But till date, you have not submitted your claim for MMCC to this office. Hence, you are again advised to submit your MMCC claim file to this office along with the all required format and documents for taking a further needful action in the matter. So after this letter, Your Lordship, the question is, and it is a decided fact, that the delay and latches are not on the part of the ECL. Till date, Your Lordship, apart from the writ application, no approach has come forward on the part of the wife of the deceased that she wants MMCC. In terms of the clause, Your Lordship, if employment is not given, admittedly MMCC has to be given. But the question is, it should not be from the date of death. It should be, in this particular case, from the date of the filing of the writ application, because the delay and latches is entirely on the part of the wife of the deceased. To that effect, Your Lordship, I can place 1 or 2 judgments, Your Lordship.
So according to you, compensation not from the date of death, but from the
date of the
filing of the writ
application. And in some of the observations of the Honorable Apex Court, it has been stated at least from the last 3 years. There they have stated from the date of the application, but here since no application has come up, I'm referring to the writ application. Because the observations that my learned friend has referred to, there might have been some delay and latches on the part of the respondent authorities. This is distinguishable in the present facts and circumstances of the case, Your Lordship. So therefore, Your Lordship, my humble submission is that the employment cannot be given. That is an admitted position. MMCC has to be given, but not from the date of death, but from the date of the filing of the writ application. Because in 2021 also, even after this letter, she didn't opt to approach. And the tabular form, what my learned friend has shown that everything was processed. It is processed because screening was done and everything was processed. That is the tabular sheet. What has been indicated there as processed. There is no dispute into it. Point is that since she didn't apply, she didn't come forward to get MMCC, Your Lordship. This writ application has finally come up, wherein we are before Your Lordship to address and make necessary submissions so that it can properly adjudicate it, Your Lordship. That is the reason my humble submission is that as per the observation of the Honorable Apex Court, Lordship, the Honorable observation is...
Counsel, no. Learned Counsel, place the pages where from it will reveal that it is the inaction on the part of the petitioner
because Your Lordship,
given to this situation.
Because Your Lordship, the annexures speaks. In my opposition also, I have referred some of the annexures in Annexure A. In 2020, Annexure A, 15th June 2020, Your Lordship.
Yes,
your claim for employment.
Place the relevant portion.
Relevant portion in the last paragraph. You are therefore requested to furnish your application for MMCC in lieu of employment at the earliest.
That is the request. Prior to that.
When did he apply? That is
place the entire letter. The area manager.
The area manager Shodhpur such and such has informed that the chief manager Saktoria undercover at his file number such and such has returned back your claim for employment as because your present age is about 50 years. So it would be just and proper to opt for monetary compensation. And repeatedly we are asking. It is not the fact in 1998 the employee died. And when did she first approach for employment? And we did the screening. That is then in the
from Annexure A, it does not reveal that there was inaction on the part of the petitioner. Thereafter, the next
inaction is on the part that she didn't approach for MMCC. She is still clinging for employment. Next page also, Your Lordship. This is the letter of I Srimati Anna Bauri, wife of Deepak Bauri. My husband expired on 11th October 1998 and death certificate issued by medical officer Barmondia Colliery, supported by Gram Panchayat of Gram Panchkeria, dated 13th October 1998. I am still widow. I am having 3 sons, namely Mithur Bauri, Dubal Bauri and Bavan Bauri, and 1 unmarried daughter. I am not in a position to accept monetary compensation. in lieu of employment, and my elder son Mithun Bauri is still minor and not able to take employment. Hence, please process my employment cannot be granted there because of the age bar that has been indicated. But she was adamant with the employment. That is the reason the entire process could not come to a logical conclusion and to a finality. Had it been the situation that she opted for MMCC at that point of time, she would have got the money from 2020 itself. From the date of death might be from that at that situation, Your Lordship. And in 2014, in the writ application, my lord will come up to page 41. He's the wife of
1 minute, Lord, confirm.
What was the situation in 2020? We in 2026 also the same situation.
Till this letter is dated, Annexure B is dated.
Annexure B is dated. It is an undated letter. It seems it has been received. No, the dated. It is an undated letter. At the bottom, it has been written, but it is an undated letter. It seems because at the top there is no letter date.
So
It's a letter of 2010.
Committee. Can be presumed to be of the latter part of 2010 or maybe 11.
We can take from 10 also because so if it is from 10, Your Lordship, then it is presumed that earlier also the same situation was there. Employment was
According to you, till 2010, she did not prefer any monetary compensation.
She always sought for employment.
She always sought for employment.
Even in 2021. When we have approached the wife of the deceased.
Ultimately, when she changed.
She didn't change. She changed by filing this writ application. That is, it was affirmed on that maybe the date when she changed her mind. 9th July 2025. Lordship, apart from this, there is a Supreme Court observation, although under Appell's Court. If my Lord permits me, I can place it by course of tomorrow. That says, or by today itself, if my Lord permits me. Otherwise, Your Lordship, my submission is this much, Your Lordship. There is no delay on the part of the ECL authorities. For which it can be.
After providing that authority, Mr. Ghosh will be able to give the reply.
It is Dukni Bhoya. Mr. Ghosh is very much aware. That is 3 years. It states that 3 years.
The citation?
Citation, Lordship, pardon.
Well, I have also annexed that judgment. My learned friend need not to, my lord, travel for that. His judgment has been distinguished. I will show to your lordships from the other judgments. This is not the judgment. This is the order passed under Article 142, which is not binding.
Mr. Ghosh, in which item?
My lord, this is আছে সব আছে
Because the petitioner has voluntarily relinquished her right to take employment, MMCC, from the date of death.
page 38
Page 38.
my lord. May I read, my lord?
Yes, yes.
Leave granted, learned counsel for the parties having regard to the facts and
Mr. Ghosh, 1 minute. Apart from this, nothing more to be
Nothing more.
submitted. Yes.
leave granted, third learned counsel for the parties having regard to the facts that the respondent had not applied for the appellant management for seeking monetary compensation upon the demise of her husband, an employee of the appellant, who had died in September 1998, till as last in the year 2020, were of the opinion that the interim order passed by this court on order dated such and such directing payment to the respondent amount in terms of the clause number such and such as amended up to the date for the period reckoned backwards for 3 years prior to the date of the writ petitions was filed by the respondents in the High Court should suffice in the interest. We have informed by the learned counsel for the parties that the amount due and payable on the period being calculated as directed order dated such and such have already been released by the appellant in favor of the respondent. In view of the said position, the impugned judgment and order dated such and such passed by the division bench passed in the runner single judge are quashed and set aside. It is held that in the peculiar facts and circumstances, the respondents waited for almost 20 years before approaching the court by filing the writ petition seeking monetary compensation from the appellant. The amount as directed by the court is adequate to meet the ends of justice. So this judgment is not applicable here because
Herein it is held that in the peculiar
facts and
case,
circumstances.
where the respondent waited for almost 21 years before approaching the court by filing the writ petition.
So my lord, that judgment, there was no 20 years, by this time there was no application for employment, nor application for monetary compensation. In my case, up to 2023, I have shown to your lordships, they have processed my employment. Now my lord frame blaming that 2021, they have, my lord, approached the writ petitioner for payment of compensation. But whereas on the other hand, a person will, my lord, think for employment because employment is more beneficial. Can you see page 46? Page 46, employment processed.
1 minute. Page 46. Yes.
My lord, page 46. Can you see? Employment process. This is their also admission in their opposition. Yes, they have processed the employment up to 2023. In 2001, in one hand, they are saying they offered MMCC. On the other hand, they are processing my employment. A person, how he sees, we will understand. Now, is there any letter that your employment has been regretted? Have they served any kind of letter? They have never intimated, even not in the opposition, that my employment has been regretted on such and such date due to this reason. Now my understanding showing the age. Now age is 50 years. But when I applied, I was about 20 years. when they have conducted medical in 2013. I was 23 years of age. In 2013, they have conducted medical and found me fit for employment. That's why they placed my file for, my lord, final.
Have you annexed that one?
Yes.
In which page? So why new medical board is required to be constituted?
No, medical, they have conducted medical for my fitness.
You have submitted that a medical board be constituted to assess the age.
At the time, they have my lord,
assessed earlier on.
No age they have not assessed. They have accepted the date of birth declared by my husband.
Just now you were referring to that in the year, which year you
kindly see
the age
page.
of the petitioner was 23 years.
No, as per their calculation, I am saying.
Yes, and as per their calculation, wherein you have annexed.
My lord, page, my lord, 34. Before that, my lord, কোথায় গেল premium?
Lordship, page 34, it says that
Page 38, can you see?
the authority sought for the death certificate also, original death certificate.
You are requested to kindly examine the following
1 minute.
audiometry.
You are requested to kindly examine the following audiometric.
They will be subject to initial pre-medical examination. This is the final stage for getting the employment in 2013. And thereafter, my lord, they have, my lord, placed my file in their website since then and pending till today. Till today, because this writ application was filed, I have annexed their document as published in the website. Now they have discontinued that, my lord, site. So at this stage, I'm not asking for any employment. I'm asking for only monetary compensation with interest. Now, a lawsuit will find the Supreme Court judgment where directly Supreme Court has said that to pay the monetary compensation from the date of death. Page
In spite of proceeding for the appointment.
Yes.
Wherein?
269, kindly see. The 273, paragraph 12. This is same judge who has passed this order, as my learned friend wanted to show to your lordship. I have shown. Dukni Bhuya.
It's 273.
269 or 273 the page. Here there was a direct dependent. So they have provided employment to the son-in-law. The Supreme Court has said no, son-in-law need not to be given employment, but you pay the monetary compensation from the date of death. Kindly see. According to the present appeal is allowed and the impugn order date such and such passed by the division bench and order date such and such passed by the learned singers are quashed and set aside. The appointment of the respondent number 1 being the irregular is hereby quashed. It is, however, made clear that any amounts paid to the respondent number 1 shall not be recovered by the appellant as he has rendered services from such and such, such and such. It is further deemed appropriate to direct the appellant to pay monetary compensation to the widow of the deceased employee as per her entitlement under NCWA, revised from time to time from the date of demise of her husband, the deceased employee, that is from 2005 onwards. The area computed such and such shall be released in favor of the widow of the deceased employee within 6 weeks from today, and month to month monetary compensation shall be rendered with effect from 2024 in terms of the provisions of NCWA. So Honorable Supreme Court also said that even after, my lord, giving employment, you don't recover the salary, and, my lord, the double benefit they have given on by the Honorable Supreme Court. And I will show to you also another judgment of the special bench on the issue. Page 88, my lord. Paragraph 63. Page 88, kindly come first. Page 82, my lord, sorry. This is the special bench judgment of Acting Chief Justice Nishita Matre, as her ladyship then was, Dipango Dotto, and the Honorable Justice, my lord, the Honorable Justice, my lord, Tapabhuta Chakraborty. The special bench judgment on the issue. Now kindly come paragraph, page 111.
Yes.
111. The second line from page 111. Appointment or compensation by payment of money to a female dependent of the deceased worker is automatic upon death, subject to fulfillment of the condition is clause number 9.3.4. In so far as the appointment is concerned, even no application is required to be made. In a case of MMCC, no application is required to be made. It is automatic. When they have refused employment, they are to pay from the date of death. This is a special bench judgment. Now this judgment was carried to the Honorable Supreme Court. Page 116. Delay condone in a facts and circumstances in the facts of the case. The reasonings given by the High Court, in our opinion, are correct and sound. Hence, no interference is required. This is not the simpliciter dismissal of the SLP. Here, the Honorable Supreme Court applied mine and my expressed opinion that, in our opinion, are correct and sound. So, doctrine of merger will apply with the order of the special bench, merge with the order passed by the Honorable Supreme Court. Though it is a SLP stage, dismiss the SLP. Generally, dismissal of SLP do not, my lord, constitute as a merger. But even then, my lord, since it is a, my lord, opinion has been formed and, my lord, expressed by the Honorable Supreme Court, so it may also, my lord, constitute as this is a judgment of the Honorable Supreme Court.
So these judgments are prior to the observation that I have placed.
Now, I have shown to lordship that is subsequently. Judgment কতবার সঙ্গে সঙ্গ বলবো সাথে সাথে অ্যান্সার বললাম 2023. My lord, that judgment, page 39, which my learned friend, my lord, though it is under 142, under peculiar facts and circumstances, but still, since my learned friend is referring, that is at page 39, you'll also kindly see the name of the judges and the date of the order. 2023, Hema Kohli and P.S. Narasimha. ওটা কত বললাম পরেরটা
16
Now, page 269. Kindly see the order date, page 269. Kindly see the name of the judge, Hema Kohli and Asauddin Amanullah.
March 5th March 2024.
Yes, subsequent that judgment. That is not judgment. That is the order under the peculiar facts and circumstances. Though there was a, since there was a no application made to them, directly writ petition was filed. That was my matter. I know the entire facts. Direct writ petition was filed after 21 years. No application for employment, nor application for MMCC. And even in their reason orders, kindly see, when the Honorable Court directs them to consider the representation, what is the stand of the respondent authority? Of the director personnel, page 241, kindly come. Page 241, this is the reason order. When there is a direction by this Honorable Court to consider the representation, simplicity order. Now, page 2,
You are referring to page 41.
241,
241.
241. This is the reason order passed in another matter. When this honorable court directed for consideration of the representation, they have passed reason order. Kindly see the last page of this document. Here also date of death was 1999. There was a prayer for employment. They have not provided. There was a delay. All this point they have argued. As such, in the interest of the justice, I feel it proper that the widow of deceased employee Sanjuab Bhuiya may be paid monetary compensation and applicable rates from the date of death of the deceased employee till she attends.
Which page you are referring? Which page?
Last page of this reason order, my lord.
243.
243.
Hmm.
They have discussed. I am not reading all these things. This kindly see the letter. Binoy Ranjan, Director Personal, Eastern Coalfield Limited. Now he is presently Director Personal of Coal India Limited. This gentleman.
Different.
Yes. Everything is different. Both of us also different. As such, in the interest of justice, I feel it proper that the widow of the deceased employee, that is Sanjuva Bhuiya, may be paid monetary compensation and applicable rates from the date of death of the deceased employee till she attains the age of 60 years upon completing all formalities. Now, this is the one reason order. Second reason also same line passed by the Director Personal, page 247. This is their consistent stand. Even in the administrative side, they are giving benefit. Can you see the last paragraph of this document? Same person has signed. Director Personal is the highest authority of the company. Geeta Bauri may be paid the monetary compensation applicable from the date of death of the deceased employee. Another reason order I have also passed 248.
Lordship, situations are all different. These are not similar situations, Your Lordship. All this is the reason order
251.
which has been passed.
I feel it proper that the widow of the deceased employee, Jyoti Devi Khoira, may be paid monetary compensation applicable rate from the date of death of the deceased employee till she attains the age of 60 years. So this is their consistent stand. Even up to Supreme Court, they have, my lord, not.
In respect of similar circumstance.
Similar, my lord, widow claim employment either for herself or for her son or for her, my lord, the son-in-law or brother-in-law, and ultimately they fail to provide the employment. Widow disease has spread. And if your lordship allow me, I will show to your lordship the judgment as my learned friend insisted. Order. This honorable court taken into consideration the many of the judgments, and they have said this is not applicable because under the peculiar facts and circumstances. In this compilation I have. If your lordship desire, I can show to your lordship. Page 293.
Yes.
293. Paragraph 12. May I read more?
Yes.
Then advocate of the appellants also submitted the payment of administrative petitions were deducted from the date of death of the employee in a case before the learned single judge of the court in a case of Dukni Bhuiya. The order so passed on November 16, 2021 was assailed before the coordinated bench of this court, being mat number such and such by a judgment and order passed on 2022. This judgment and order passed by the single bench was affirmed. Directed the payment of MMCC from the date of death of the employee. Mrs. Eastern Coalfield Limited carried a special leave petition before the Honorable Supreme Court The Honorable Supreme Court was pleased to quash and set aside both the orders passed by the single bench and coordinated bench of this court and limited the payment of MMC 3 years prior to the date of filing of the writ petitions. So this was their submission recorded. Now kindly come. পরেরটা তো ওইগুলো পরপর কোনটা পড়বো বলতে বলে পড়ছি হ্যাঁ 3 years prior to the date of filing বললাম তো thereafter another judgment the appellant also relied upon the decision of the coordinated bench in a full devi where the claim of marriage was also allowed from the date of death to process the claim.
What was the finding herein?
Yes.
Ultimate finding?
Ultimate filing, I'm coming, my lord.
Lordship, in this particular judgment, the Honorable Court has been displeased to distinguish the several facts and has finally come to the conclusion. So Dukni Bhuya has been referred there.
The husband, paragraph 21. First, my lord, kindly come paragraph 20. The landed advocate for the writ petitioner has drawn our attention to the reason order. Just now I have shown to you, lordships. The Eastern Coalfield in the case 1 of Sanjeev Bhuya, monetary components were directed to be paid from the date of death. It is a content that the authorities cannot discriminate between the similarly circumstanced beneficiaries. The benefit extended to one should not be uniform, should be uniformly applied under the similar circumstances. In support of this case, he relied and placed Purnendu Mukhopadhyay such and such. The husband of the writ petitioner respondent, namely such and such, was an employee of ECL. The said employee died on 2010. The writ petitioner applied for compensation appointment to her son Rajesh Munda. The other legal heirs of the deceased employee, namely the sons Diku Munda and others, daughters such and such, by writing date 2003, expressed their no objection to such employment. Such application for compensation appointment of the son of the deceased employee was processed. Here also processed. Several communications were exchanged between the parties. The son of the deceased employee, by letter dated 2015 from the assistant manager, was asked to appear before the area screening committee. Here also same. Ultimately, such application for compensation appointment rejected in writing date 2018. Here, my lord, there was no rejection by them in my case. Upon rejection of the claim of the such and such appointment, the writ petitioner by application they requested for release of monetary compensation from the date of death of her husband. In the said letter, the petitioner specifically stated that she had received death cum retirement benefits. Provident fund, such prayer of the writ petitioner having been allowed, the writ petitioner approached before this court filing writ application. 6% allowed. Thereafter, the paragraph 25, the materials placed on record demonstrate that the appellants are aggrieved by the impugn order of the order dated such and such claim MMCC from date 2012. As such, the landed single ought to have directed payment MMCC from the date of application of 2022 instead of 2010. It was also contended that since the appellant never claimed MMCC, the appellants were not at fault. The direction payment interest upon the amount was not justified. Thereafter, my lord, the series of facts were discussed. Now, paragraph 35 is a long judgment. Putul Ravidas also, my lord, the special bench judgment taken into consideration. Tarsem Singh, all judgments have been considered. Now, my lord, kindly come paragraph 35. The Dukhini Bhuya.
Yes.
In a case of Dukhini Bhuya Supra, the Honorable Supreme Court in a civil appeal preferred against the order passed in appeal from the order of single judge, limited to such claim for MMCC to 3 years prior to date of filing of the writ petitions in the High Court. In consideration of the peculiar facts of the case,
The particular facts of the case.
Particular or peculiar particular. In a case, and however, the peculiar facts, next paragraph, noted in the case of Dukhni Bhuya do not exist. The delay in approaching the court by writ petitions has been sufficiently explained in this case. The husband of the petitioner died in 2010. An application for employment of the son of the deceased employee was promptly made. Here also same. In a month of the death of the employee, the authority took more than 10 years. Here, my lord, they have taken, my lord, more than 30 years. In considering such application for compensation appointment, which was ultimately disposed of in 2018. Thereafter, writ petitioner approached the authorities and ultimately the court for MCC had the authority decided on the application for compensation appointment within reasonable time. The writ petitioner could have approached the court much earlier. The appellant cannot be allowed to extract benefit of their own wrong. In the facts of the case, then our full Devi was, my lord, discussed. Both the major, all judgment have been, my lord, discussed. All compilation I have, my lord, placed before your lordship has been discussed. And finally, my lord, kindly come. In light of the discussion made here above, we do not find material to interfere with the findings of the single judge so as to entitlement of the private respondent petition in the MMCC on the account of death of our husband from the date following the date of death. We also do not find reasons to interfere with the direction of payment of interest on the due amount with effect from such date. We find no merit in appeal. Appeal dismissed. There are other judgments, my lord, where, my lord, this order was, my lord, taken into consideration.
So according to you, it was passed having peculiar
Yes,
circumstances.
this is under 142. This is not applicable. This is not the
This is
precedent.
also peculiar circumstances, similar circumstances. We have regretted long time back.
Let us show any letter that they have regretted. They have processed up to 2023. How they can say?
Processed. We have processed and equally we have sought approach that please
No,
apply
it,
for
it
MCC.
cannot be both.
Learned Counsel, apart from your verbal submission as regards to regretting the appointment, can you show any document wherefrom it will reveal?
2 affidavits they have filed, my lord.
Regarding that employment has been regretted. Lordship, in the letter itself, it states that employment cannot be given since you have attained the age of 50 years. It is the letter which shows it has been regretted. And please go for MMCC.
That is in the year 2023.
No.
No.
2020.
2021 they are showing.
So
2021 they are showing. Whereas in 2023 they have, my lord, shown is processed. And till date it is processed. And there is no abatement even in the affidavits.
in 2020, your lordship, the letter that I have annexed. In 2020, I have annexed a letter, your lordship. There also we have stated. So that is the
Which annexure? Which
annexure A, page 15.
Yes, 15/6/2020.
Your file has been returned by your claim for employment as because your age is 50 years. It will be just so that is the it is absolutely.
Case is 50 years, my lord, at this stage. When I have applied.
As because your present age is about 50 years.
Lordship. So it will be just and proper to opt for MMCC.
Just and proper. That does not mean that they have rejected. So again, my lord, I have seen in the website that they have processed.
As she had attained, as at that relevant point of time, she had attained 50 years. So the
please apply for MMCC.
so
that is a
appointment
matter of rejection.
should not be considered having attained age of 50 years.
Lordship, the exact word might not have been written, your lordship, but this essence of this letter is simply clear.
So in
It's amply clear, your lordship. that employment
2020,
is shut
then
down, it cannot be given.
2023, even today, their website shows that it is processed. It is there, but a person cannot be get benefited for his own fault.
Heard the learned counsel representing the petitioner in full, and the learned counsel representing the Eastern Coalfields Limited. Full stop. And, do you intend to file any?
No.
Written notes.
Written notes?
My lord, we can.
You have furnished several citations.
Well, all are, my lord, ELRC is already noted.
Next Wednesday ছুটি আছে, next Friday 28th ওটা ছুটি নেই তো, খোলা আছে তো। On 28th
28th
it is holiday possible, রাখি পূর্ণিমা
রাখি তোমাদের ছুটি নেই।
ছুটি না আমার ছুটি আছে।
So on
September, your lordship.
No formal
second,
argument complete, your lordship make it
second
Argument completed, written notes. If
second
written notes.
September, 2nd September, but not voluminous one, in bullet form.
in bullet form only.
2-3 pages.
Lord, already, my lord.
It is you are very much well conversant with all the citations,
My lord.
so only in bullet form. The parties are at liberty to file written notes of argument on 2nd of September.
Second. Well, kindly, my lord, record only one thing, that your lordship argument completed, matter CAB for the purpose of written notes, my lord, your lordship fixing. Otherwise, again, my lord, my learned friend will start arguing.
No. As regards to argument, oral submission complete.
My lord.
Only for written
So,
notes.
kindly
of
record
argument.
that your lordship's the matter is, my lord, made CAB, and for the purpose of, my lord, written notes, my lord, your lordship fixing.
Oral submission has been completed on behalf of both the sides, petitioner and the Eastern Coalfields. Only for written notes.
May kindly record them.
On that day, no submission will be taken into consideration.
Make any submission.
Only for written notes of
My argument completes, kindly record, my lord. Argument of the parties have been completed.
Yes.
Key problem, আমি বলবো না কিছু।
No, তার জন্য, by any chance, in any case, if it is, my lord, changed by this time, then I will be in difficulty, my lord. Argument complete লিখেছেন? না, এটা argument of the parties.
শুনুন।
Record, my lord, the argument of parties is completed, my lord.
Can you file it earlier?
I can, but so then, my lord, do not place in the board. I will, both of us will, my lord, submit.
By 2nd September.
By, my lord,
Not this
by
week, your lordship.
by day after tomorrow, I will submit.
Next week, your.
Can you make it CAB, my lord? Both of us will, my lord. Otherwise, it will begin again, my lord.
Hand it over to the court officer. That
I will hand over, my lord. By day after tomorrow.
By 2nd.
By Friday, I will hand over.
By Friday, it will not be possible for us, for me.
There will be somebody representing you on 28th.
28th, my lord.
It will be under the heading to be mentioned. It will be under the heading to be mentioned for filing written notes of argument. শুনুন, কি হলো? না, ওটা করুন হচ্ছে, let the matter appear under the heading to be to be mentioned within inverted comma, to be mentioned only for filing written notes of argument.
And oral argument of the parties have been completed.
Concluded, huh? 28th of August.
And oral argument have been completed.
Yes.
Kindly record, my lord.
কি আছে পড়ুন দেখি, পড়ুন। Limited. আচ্ছা, ওটা করুন। verbal submission on behalf of both the sides are concluded. ঠিক আছে? Reserved for judgment. Reserved for judgment দরকার নেই। এবার to be mentioned থাকবে।
Get.
Item number 12.
Well, here, my lord, this is my exception to the report. Here. This is my reply to the, my lord, opposition filed by them.
My lord, I am filing the affidavit in opposition.
Same issue?
No. Here, my lord, daughter-in-law asking for employment.
Daughter-in-law.
My lord. The father-in-law was an employee. Then son applied. During the process, son died. Then, my lord, daughter-in-law applied. They rejected on the ground that the daughter-in-law is not entitled as per NCWA. And this matter was covered by the judgment of the single bench, division bench, and Supreme Court. This point has been clarified. Now, my lord, may I place the facts? In 2010, the father-in-law died. 2022. No, sorry, 20.
2020.
20, the
18/3/2020.
20.
Histodome.
Yes, died. Now, my lord, my husband, that is Monosa, applied for employment. Kindly come page 23. IME board under Disari, IME Initial Medical Examination Board has communicated that the IME board under Disari of the under-noted candidates will be conducted on November 2020. Kunustoria Hospital. This is details of the candidates given below. In view of the above, you are requested to arrange to inform the concerned dependents to appear before the IME board on the above mentioned date and venue along with the required investigation report and relevant documents. So, my lord, this is their pre-medical examination they have conducted in respect of my husband. Thereafter, my lord, my husband has died.
Suppose the moot point is whether the daughter-in-law is entitled. or not.
Yes, yes.
Yes,
In this particular case, under the facts and circumstances.
yes. Let him submit.
complete
Let Mr. Ghosh submit.
Now, my lord, kindly come page 24.
You will get the, you will get
Ye-
ample
Yes,
opportunity.
yes, my lord, my lord.
Kindly be seated. You will get ample opportunity.
Page 22. This is death certificate of my husband. That is at date is 27th April 2021. First thing, my lord, lordship, my lord,
What you are referring? Let it comes.
page 24.
Page
4.
24.
First, I have referred, my lord, the death certificate of the, my lord, father-in-law,
That is
18 March.
That is at page 22.
Yes, 18 March.
Father-in-law, thereafter the son. 24.
Yes, 18 March 2020. Thereafter, my lord, in October 2022, a medical examination was conducted. October
2000.
October 2022. 21st October 2022, they have written letter for medical examination. Medical examination conducted 2nd November 2020.
Which from which page we will get that?
Page 23.
Page 23. Yes.
2nd November 2020.
2nd November 2020. Wherein the date and time? Yes, 2nd November 2020.
Yes, that was a date fixed for medical pre-medical examination.
Yes, yes.
Pre-employment medical examination. Now, thereafter, 27th April 2021. Page 24.
27th. Yes, 27th April 2021. Monisha expired.
Manasa expired. Manasa is the husband of the petitioner, the son of the deceased employee. Baki death certificate I have annexed of other persons. Birth certificate. Birth certificate of my son has been annexed. Both sons of birth certificate I have annexed. Now in December, I applied page 27.
Being the daughter-in-law.
Yes. 10th December 2021.
1 minute.
I have applied and all documents I have annexed. Now page 38.
10th December 2021.
They have regretted. Or may I read?
Yes, you are referring to page 31.
Page 38.
38. Yes. Employment proposal of dependent of late Histodome. Yes.
My lord.
Place it.
The employment proposal of the dependent of Kestrodome, ex-Tramar, Sajan of New Kendra Kalori, expired on March 2020, has been received on examination. It has been observed that the son of Kestrodome, Sri Manasa Baddakar, applied for employment, which was processed and sent to HCL headquarters. We have received a letter of Padma Dome of wife of late Sajan, which she informed that the Manasa expired on April 2021. In her application, she also nominated her daughter-in-law, Malati Baddakar, for employment against death of her husband. We have received another application by Srimati Malati Baddakar, where she claimed for employment against the death of her father-in-law. It has been observed that Padma Dome of wife of late Sajan is still alive as direct dependent. In this situation, this is to inform you as per the provisions of NCWA, Malati Baddakar, wife of late Manasa Baddakar, is not eligible for employment. Hence, it is advised to Padma Dome to submit claim for employment, claim for MMCC along with all supporting documents at the earliest for further necessary action from your end, which may be effective after proper approval from competent authority. Now, after that,
So the reason is that Podda Dom, the wife of Kishto Dom, is still alive. So Malati Baddokar cannot be given employment. Yes.
thereafter, Padma made another application before them, page 39, before the director personnel, that I have no other means of family. Hence, I request you to kindly folded hand to please arrange employment to daughter-in-law Malati. So again, he has sought for the employment of the Malati. These are very short facts.
Lastly, you have referred to page. Apart from 38, you have lastly referred to.
Lastly, I have page 39.
39. Therefore, I have applied for employment of my son, but unfortunately, hence I would request you to arrange for employment of my made by the mother-in-law.
Mother-in-law.
Of the dom, yes.
Now, this is the fact.
This is the fact.
Fact is very short. They are asking for application from the mother-in-law for providing MMCC, as the mother-in-law is the dependent of the deceased, is the first category of the dependent, and there is no provision for employment of the daughter-in-law in NCWA. So employment to the daughter-in-law cannot be given. These are the facts. Now, I have placed single bench judgment on the same point. Single bench division bench Supreme Court. It will be in the file.
That one.
No, another judgment I have given before the earlier bench, my lord. নাই ছেড়ে দাও তাহলে না ডিভিশন বেঞ্চটা আছে তাও নাই কি বলছো দু কপি আছে সুপ্রিম কোর্টে হ্যাঁ অর্ডারে লেখা আছে অলরেডি রিটেন ইন দি অর্ডার
অর্ডার বুক এটা
আগের অর্ডারে লেখা ইয়ে আরতি মুর্মু May I read the fact? The facts of the both matters are very much required to be considered.
Which paragraph?
But I need to read the entire facts. Otherwise, single bench. The petitioner's father-in-law, namely Nunulal Hemrom, was an employee of ECL, died in harness 2019. His son Krishna Kumar Hemrom, that is the petitioner's husband, applied for appointment under the provisions of Chapter 9 of the NCWA as a male dependent. The application of the petitioner's husband was processed and his appointment was approved. The place of the posting of the petitioner husband was also notified. At this juncture, before joining ECL, the petitioner husband died. Here also the same fact. The petitioner is therefore the widow daughter-in-law of the deceased employee. The employee's wife, that is the petitioner's mother-in-law, had applied before the ECL authorities for granting job to the petitioner. Same fact. Since this application has been regretted, the petitioner has approached this court seeking redressal. On behalf of the ECL, it is submitted that the petitioner was not a dependent in terms of the clause number 9.3 of the NCWA. It is further submitted by ECL that the cause, if any, to get compensation employment crystallized on the death of the employee, that this is on 16 June 2019. The petitioner husband, being the son of the deceased employee, was alive at that point of time, and as such, the petitioner was not dependent in terms of the clause 9.3.3 of NCWA, and this therefore not entitled for compensation employment. In support of this contention, the ECL has relied upon the judgment dated such and such. The petitioner says the petitioner come under the indirect dependent as mentioned clause number 9.3 of the NCWA. The petitioner says that the husband of the petitioner, though was given compensation employment, but before he could join, he passes away, and as such, for all practical purposes, no compensation employment was given by ECL. After the death of the petitioner husband, the petitioner is entitled to compensation employment as an indirect dependent in terms of clause number such and such. The petitioner has relied upon judgment reported in Anadimukta Sadguru and the judgment dated such and such passed in a Kajoli Paddakar. The relevant paragraph relied upon, it is evident that for the following date, the Kajoli has been affirmed to such and such. Now, we propose to deal with the nature of the NCWA. The NCWA negotiated agreement between the employees of the public employee.
The issue is indirect dependent.
In his same fact, same.
Clause 9.3.3 of
Yes.
NCWA.
Same fact. Facts is same. They are also father-in-law. Mother applied for employment.
They
Here
are
also father-in-law, mother applied for employment. Now, we proceed to deal with the nature of the NCWA.
The only difference is that herein, in the judgment of Arti Murmu, the son was provided with the appointment, but he could not join.
Before joining, he
expired prior
died.
to that.
Yes, before joining, he died.
But
And here also they have
case,
they have kept under process.
it was under process. So
Only this much difference.
now.
Grateful to Lordship. Now we proceed to deal with the nature of the NCWA. The NCWA is a negotiated agreement between the employees of the public employer and as such. And such employer arrived at after collective bargaining and prolonged deliberation. It is a product of meeting of minds. It is not a product of a unilateral decision of the employer or the employee. It is a statutory force and parties therein were adequately represented from both the employers and employees side and had completed all situations before identifying the classes of the persons who sought to be kept in a live roster, implying thereby that the class which is not included in the relevant clause of the NCWA are consciously excluded. The NCWA has been revised from time to time and fresh agreements and settlements were arrived at with modifications of previous settlement and introductions of the additional benefit to the workers, keeping pace with the change of situation. Pace of the with the change of situation, but the relevant provisions 9.3.0 has never been altered. The NCWA made provisions for compensation appointment or in the alternative monetary payment of compensation for the dependent employees of coal companies under such and such clause. It is a decision of the learned coordinate bench of this court in Eastern Coalfield Limited versus Dilip Singh and others reported it has been held that it was not open for the court to rewrite the terms of the scheme for compensation appointment provided in NCWA, but compensation appointment being a privilege extended and an exception to the general rule of recruitment and in given terms of the scheme should strictly be construed and such appointment was not a heritable right. The relevant portion of the said judgment quoted. It was quoted. Right to compensation appointment is an exception to the general rule of the recruitment by public competition. Such privilege therefore is to be strictly construed according to terms and conditions of the scheme and same cannot be rewritten by the courts in Bhavani Prasad. So all this judgment was quoted. Now it is well settled that held in such and such that the policy of compensation appointment is premised on the death of the employee while in service. The death of the employee is liable to render the family in a position of financial hardships and need. Compensation appointment is intended to alleviate the hardship that the family of the deceased employee may face upon premature death while in service. Compensation appointment, in other words, is not founded merely on parentage or descent. For public employment must be consistent with the quality of opportunity which Article 16 of the Constitution guarantees. Hence, before the claim of compensation appointment is asserted by the family of the deceased employee or is granted by the state, the employer must have rules or a scheme which emphasize such appointment. It is in that sense that it is a trite principle of law that there is no right to claim compensation appointment divorce the scheme. Even where there is a scheme for compensation appointment, an application for engaging can only be considered in accordance with the subject to fulfilling the conditions of the rules of the scheme. Held in the coordinated bench in the judgment Putul Ravidas. Just now I have shown to the another matter, my lord. The clause unmarried daughter is diluted to include divorced daughter. Actually, unmarried daughter was there in the clause. Now, in the Putul Ravidas, the unmarried part has been diluted. And my lord included divorcee daughter as well for granting compensation appointment under the National College Agreement.
So, earlier it was only unmarried.
Unmarried.
Now it has been extended
Extend
to unmarried plus divorcee.
unmarried plus divorcee. Now it has been extended unmarried, divorcee, widower, and married. Another judgment replaced.
Married has also been.
Yes, that has been that clause, particular clause has been held ultra virus, in my judgment. Passed by my Lord Justice Saraf and upheld by the division bench. That clause, unmarried part, married daughter will not get employment, only unmarried. That part has been held ultra virus to the Constitution of India. I have argued before my Lord Justice Saraf, as his lordship then was, and it was challenged before the division bench. Division bench also. That is not the question. No, that is not the question.
Herein the issue is indirect dependent.
Indirect dependent, and the clause unmarried daughter is diluted to include divorcee daughter. Thereafter, in Eastern Coalfield, Kumari Kiran Singh, others, wherein the aforesaid precedent was upheld and binding clause, nature of clause number 9.3 is 9.5.0 is accepted. Moreover, in Madhubala Sinha, Ranchi held that sister and mother should also be included as dependent in the ambit of 9.5. So, sister and mother was not the dependent, but in the Ranchi High Court, Madhubala, Sinha versus the mother and sister has also been now included in the NCWA. In that view of the matter, irrespective of the quantum of death benefits that has dependent might have received owing to the death of your father, mother-in-law, such and such, ECL cannot be reputed a claim for compensation appointment or monetary compensation on the ground that the family having received substantial death benefits is not need thereof. The terms of NCWA 6 are such that a dependent, if she satisfied all conditions, is dependent of the deceased worker and has the requisite qualification for giving an employment by ECL, is entitled to claim that he ought to be extended the benefit compensation appointment or monetary compensation as the case may be under clause chapter 9, with the only exception that delay in claiming compensation appointment may disadvantage such relief, while delay in claiming monetary compensation may curtail the period for the same. The question as to whether the petitioner is a dependent of the employee who had died in harness and stand in the relation to the petitioner as her father-in-law cannot be answered directly by referring to the NCWA. So, my lord, this judgment has, my lord, having my lord the the another angle. This judgment not was limited to the NCWA, but the definition of under Workmen Compensation Act, because chapter 9 of NCWA prescribes and my lord borrowed the concept of Workmen Compensation Act 1923. So that's why the Honorable Single Judge borrowed the concept and the definition clause from the Workmen Compensation Act. Now, my lord, kindly come. The question as to whether the petitioner is a dependent of the employee who had died in harness and stand in relation to the petitioner as her father-in-law cannot be answered directly by referring to the NCWA and the Workmen Compensation Act 1923, which is now known as Employees Compensation Act 1923. NCWA under Chapter 9, which provide for social security in clause 9.2.1, states that the employees covered by this agreement shall be entitled the benefits admissible under the Workmen's Compensation Act 1923. So already the concept and the formula that has been adopted by the Parliament through the Workmen Compensation Act has been adopted by the NCWA in toto. Section 2D of the Employees Compensation Act 1923 defines dependent of the deceased employee. In Section 2D1, Roman 2E, a widow daughter-in-law a dependent of the deceased employee if she is wholly or part dependent on the earnings of the employee at the time of his death. So the Honorable Single Bench means to say.
So what was the age of the son at the time of death of the
37.
37.
So
what was he doing? The son?
Nothing. A dependent of the deceased employee if she is wholly or in part dependent on the earnings of the employee at the time of death. So, under the Workmen Compensation Act, the widow daughter-in-law or the widow of or the widow daughter-in-law is dependent if she is wholly or in part dependent on the earnings of the bread earner. So here the family was dependent upon the entire family was dependent upon the father-in-law. Now father-in-law, then my lord, his wife, that is my mother-in-law, and the husband. Husband is direct dependent. Now husband has died. They could have given the employment within a, my lord, very shortest possible of time. The Honorable Supreme Court has says from the my lord.
Prior to giving appointment to the son, they must have inquired in the report. Is there anything? There's iota of evidence as regards to that the son was unemployed. Was
No, the honorable. That's why they have processed.
wherein have they filed any report or anything?
In their my lord, yeah, my lord, in writ application I will show to your lordship. First paragraph, page 38.
Yes,
the employment proposal of the dependent of such and such. First paragraph, page 38.
Yes.
Man number has been received. On examination, it is observed that son of late Kestodasi Sri Manosa Baddogar applied for employment, which was processed and sent to headquarter ECL, sent to ECL headquarter, processed and sent for providing employment. So they have inquired everything and they satisfied, then only they have processed and sent to headquarter for final approval. Now, thing is, my lord, the Honorable Supreme Court time and again reiterated that in a case of compulsory employment, the fate of the application has to be decided in a time-bound manner within a period of 6 months from the date of death. Here, 6 months has already been elapsed. Had it been the case that after the joining in the service, he died, my son, my husband would have died, then a question of this kind, second category, first category would not arise. Automatically, I would have given.
She would have come.
So now, now may I read the judgment, madam?
1 minute. Kishtodom expired during the month of March 2020, and when this Monosha was given the appointment.
Appointment was claimed immediately, my lord.
No, not claimed. When he was given the appointment, he could not join, but appointment letter, but anything final.
Which one?
The decision of the ECL that
this judgment
that Monosha will be given the appointment.
No, that has not been communicated.
Not communicated.
No.
You have mentioned that Monosha could not join in spite of having the appointment.
No, that is not Monosha. This is this judgment. In this judgment, which I was reading, Monosha is, my lord, in respect of the writ petitioner.
Yes, Monosha is the son of the
yes, deceased employee.
Deceased employee. No, herein, please.
My lord.
Please proceed.
My lord, paragraph 13 I was reading.
13.
The deceased dependent of the deceased employee, if so wholly. Well, this is a very vital part I am reading again, my lord. Section 2D, paragraph 12, the last page, page 6.
You have referred to that one.
Yes. 2D of the Employees Compensation Act defines dependent of the deceased employee in section 2D, Roman 2 within bracket E. A widowed daughter-in-law is a dependent of the deceased employee if she is wholly or in part depend on the earnings of the employee at the time of his death. The Honorable Single Bench as to why accepted this concept, because NCW itself adopted the Workmen Compensation and the Employees Compensation Act for providing employment.
Yes.
Now, in the instant case, at the time of death of the employee, his son, being the husband of the petitioner, was dependent on his father's income, either wholly or in part, Only upon finding son to be dependent on his father, the ECL had given compensation appointment to the son. However, the son unfortunately died after being offered the compensation appointment, but before accepting the same, by actually joining the service of ECL, the petitioner being the daughter-in-law, this analogy was dependent on her husband, who in turn was dependent on his father-in-law. If it is to be held that the petitioner was either wholly or in part of the dependent upon the income of her father-in-law, the petitioner therefore qualifies as a dependent of the deceased employee, as such entitled to be benefit provided under Chapter 9 of the NCWA. In the facts and circumstances as aforesaid, the petitioner entitled to compensation appointment in ECL. In the event petitioner has surpassed the age of 45 years, she shall be entitled to monetary compensation. ECL shall take expeditious step to either to give appointment if below 45 years or on the date of filing of the writ petitions, or else provide the MMCC to the petitioner. Here, my lord, employment was provided because she was below 45 years. Now,
by the appellate court?
No, appellate court.
Affirmed.
Yes. Fact I am not reading, my lord, because same fact has been quoted here. Paragraph 18.
Yes.
I'm reading only ordering portion. Initially, the widow of the deceased employee relinquished her claim to appointment on compensation ground in favor of her son, who has died later on, before he could join. The writing later dated such as issued by the authorities of ECL exhibits that by such writing, the widow of the deceased employee was informed about the rejection of her application for appointment on the petitioner. The said letter also invited the widow to claim monetary compensation. Same situation. Compensation, however, no appointment on compensation ground was offered to the widow of the deceased employee, possibly in terms of clause number ato. In view of the facts and circumstances, since no direct dependent was available, and indirect dependence as widow daughter-in-law of the deceased employee, the petitioners was entitled for such appointment in terms ato. In light of the discussed merit above, we do not find in the merit in the impugn order. So appeal is accordingly dismissed. Now Supreme Court, my lord, SLP. SLP simply said dismiss. There was no caveat, one-sided, my lord.
The special leave petition is dismissed. Yes. আচ্ছা এই তিনটে একসাথে স্টেপল করে দেবেন এই তিনটে একসাথে স্টেপল করবেন yes anything more?
No. I will reply, my lord, if necessary.
Yes. Lord Counsel.
My lord, the employee concerned died on
18/3/2020.
20. Thereafter, as per proposal made by the widow of the deceased employee, his son,
Monosha, in respect of Monosha, it was being proceeded. Ultimately, Monosha also expired on 27th of April 2020.
my lord, process means, I think entire process was not completed because he was called for medical board. Whether he has been declared fit or not, that is also not known to us. Whether he appeared or also, that also we do not know. And they have not also contented that they have, he has.
Counsel, you cannot deny that he did not appear before the board because it was you, the employer, who had called for the medical examination, and it must be the employer who will have the record whether the person had appeared or not. You cannot deny. If you do not have any document in support of your
My lord, it is true that during the process of employment, of the son of the deceased employee, he died. Now, first I will rely the provision of NCAA. Clause number 9.50, subclause Roman 2 provides that in case of
Learned counsel, be kind enough to provide a copy of the same.
just now I am giving, first I am reading, only one copy I have. Sorry, my lord. In case of death or partial disablement due to cause other than mine accident and medical unfitness under clause number 9.40, if the female dependent is below the age of 45 years, he will have the option either to accept monetary compensation or rupees 3,000 per month compensation.
That is monetary compensation.
Monetary
Per
compensation.
month.
My lord, under this clause, first, it is NCAA, it is not a legislation. It is a pure bilateral agreement between the parties, workman side and the employer side. And a specific stipulation that when a employee dies in harness, in the first hand, the female spouse will be entitled to get employment if she under the age of.
She had surrendered in favor of his son, in favor of her son.
Yes,
Who
that
ultimately expired.
that is also permissible. If instead of her employment, if she applies for the employment of her son, he being the direct dependent of the family, that can be considered. And accordingly, his case of employment was processed, but no employment was given to him. In such a situation, only the spouse who is surviving at the time of death, she is entitled to get either compensation or employment if within the zone of required age. Now, but the question of giving employment or other compensation may arise.
One thing may I clarify? Compensation, son is not entitled, male is not entitled, male is not entitled, male
Correct.
is submitted wrong.
Compensation only can be given to the spouse. Correct.
Female, not the male.
So, if a policy and as per agreement, it is very clear that only when no direct dependent family member is available, only in that case, other indirect dependent like son-in-law and brother-in-law, daughter-in-law, who was fully dependent on the income of the deceased employee, he or she can claim employment under clause 9.33. তোমরা বেশি করে জানো না কেন কপিগুলো? The dependent
9.33, yes.
9.33, my lord. The
Counsel,
dependent
proceed.
in this purpose means the widow, wife, husband, as the case may be, unmarried daughter, son, and legally adopted son. If no such direct dependent is available for employment, brother, widowed daughter, daughter-in-law, and son-in-law residing with the deceased, almost wholly dependent on the income of the deceased employee, may be considered.
Learned counsel.
To dependent.
Herein,
My lord,
herein the mother-in-law was alive. Mother-in-law was alive.
Mother-in-law is what?
She had surrendered. she has surrendered in favor of the daughter-in-law.
Yes.
Yes.
In both the matters.
Huh? No,
In both the
not
matters.
son-in-law. She has
Surrendered in favor of her daughter-in-law.
no, my lord, I am coming to
In the present case.
I am coming to that point afterwards. Now, mother-in-law cannot nominate her other dependent who are not direct dependent, cannot. Under this.
This is the question being raised by you.
Yes, my lord. My lord.
Anything more?
My lord, I am giving on judgment of Supreme Court, SCC. I have quoted the judgment in my affidavit in opposition, SCC 1535. My lord, in this case, as directed by the division bench and single bench, son-in-law was given employment and he joined in the service also. On SLP filed by the ECL, Supreme Court has allowed the SLP. Even the employment given to the son-in-law has been quashed, set aside, holding that it was irregular. And clearly it has been written.
Learned counsel, prima facie, in the case of Bipin Murmu, it was a son-in-law.
Son-in-law, right.
In-law.
Son-in-law.
Does a son-in-law come within the family of a deceased employee?
Son-in-law and daughter-in-law share the same status as
My lord, I am equating these two persons.
Senior counsel, can we compare?
Yes, my lord, that is my submission. Here, daughter-in-law.
Yes. Does a son-in-law and daughter-in-law are in the same status?
Yes, my lord, for this purpose, for this judgment, spirit of law, I beg to submit that it is same. In that case, son-in-law, in this case, daughter-in-law. And NCWA, in NCWA, it is very clear, when direct dependent is available, no indirect dependent can be permitted to get that benefit. Yeah, and accordingly, in such a situation, Supreme Court clearly said that when, my lord, I am reading the observation of Supreme Court. My lord, para 10. Para 10 of the judgment.
Yes.
In the present case, admittedly, the wife of the deceased was alive and he is still alive and she is still alive. Since she had crossed the age bar of 45 years on the death of the demise of her husband, that is 1st August 2025, she was entitled for being granted monetary compensation in terms of clause 9.50 and not for employment. Therefore, it was a fit case where the appellant ought to have monetary compensation to the widow of the deceased employee. My lord, in this case, ultimately, as directed by the High Court, employment was given to avoid contempt proceedings. But
to the son-in-law.
Son-in-law, right. So, my lord, this spirit of judgment in my favor, my lord.
The difference between a Bipin Murmu and herein
only
is that therein also the wife of the deceased was alive. Herein also the wife of the deceased is alive. She is now aged more than 45 years.
Yes.
Therein, herein both.
Yes.
Same.
Right.
Same situation. Only the difference is therein it was son-in-law, herein it is daughter-in-law.
Right, right.
Now the word dependent comes into play.
My lord, dependent, son-in-law or daughter-in-law may be considered as dependent
according to you,
when there is no existence of direct dependent. My lord, this is a agreement between the parties, not a statute. My lord, a person cannot get double benefit under the agreement. When an agreement provides for compensation, in case of the demise of the husband employee, she has to claim for that. Since employment is much more beneficial, she has claimed.
Yes.
My lord, definition part is there for the purpose under the situation when there will be no other direct dependent. Under 9.3.3, it is very clear, my lord.
So you are stressing upon the point that where there is direct dependent, no indirect dependent can get the employment.
Yes, my lord.
That is the point.
My lord.
Anything more?
There's nothing.
Lord,
I have
on this
I
point
have
only.
taken this point in my affidavit also, sir.
Now, if you lordships kindly see the single bench order once, my lord. Your lordships has, my lord.
Supreme Court has quashed the employment of son-in-law.
Your lordships already answered my lord reply. If you lordships kindly see.
Therein, the Workmen's Compensation
Yes.
Act has been taken into consideration.
Yes. So workman compensation in the Workman Compensation Act. Workman Compensation Act has been adopted by the NCWA.
No.
Now
I do not agree, my lord. My lord.
Now, if you also kindly see on paragraph 12.
Yes, you have placed, Mr. Ghosh.
Yes.
You have
Now the
placed.
Workman Compensation Act has been accepted and adopted in the NCWA.
Submission on this. So, my lord, Workman Compensation Act provide compensation in case of sudden death due to accident or other while he is in service. Workman Compensation Act perhaps does not deal with this type of situation. Here it will be dealt under NCWA.
Workmen's
In case of accident. In case of accident, Workman Compensation Act will come.
Ultimately, death of the employee has taken place.
But normal death matter has not been covered under Workman Compensation Act.
My lord, may I read, my lord? In the Social Security, Chapter 9, 9.2.1.
Who has referred this one? You have placed.
My learned friend. Kindly see.
9.2.1.
9.2.1. The employees covered by this agreement shall be entitled to the benefits admissible under the Workman Compensation Act 1923.
But
so, my lord, so now they have adopted and accepted.
My lord,
Counsel.
I am very sorry that he is misrepresenting the fact.
That has been accepted by the single bench division by Supreme Court.
Compensation Act
My lord, this
come only in case of accident. While the employee,
this is the case of
during
Chapter
the
9. My lord,
course of employment.
kindly see, my lord.
The course of employment, if a person
kindly see, my lord, the heading of this.
makes an accident, only in that case.
Learned counsels, if both of you speak, then how
আমাকে
can
বলতে
the
দিন
court understand?
এরকম করলে কি করে হবে আমি তো নার্ভাস হয়ে যাব আপনি এরকম করলে বলতে দিন আমাকে kindly see, my lord, Chapter 9, my lord, the book which has been referred by my learned friend.
Yes.
Can you see at top? Chapter 9, Social Security. Workman compensation benefit 9.2.1. This argument, I have advanced this argument that has been accepted by single bench, division bench, and not interfered with by the Supreme Court. Now, thereafter, my lord, kindly come the 9.3.0.
Yes.
So, my lord, entire thing is under the Social Security. Employment provision start from the 9.3.0. And my lord, Social Security start from 9.1.0.
Yes.
So, under the Workmen Compensation Act, there is no definition of dependent of the son-in-law. So, there is a difference because son-in-law is not from the family. That's why Honorable Supreme Court rightly rejected his employment. But here, my lord, the lady is within the family as defined under the Workmen Compensation Act, and that has been accepted by the single bench, division bench, and not interfere with the Supreme Court. My learned friend is to, my lord, approach is to, my lord, argue that why these judgments, single bench and division bench, is not applicable. That has not been argued. As to why it is not binding before the coordinated bench as well as the higher bench, higher quorum has delivered the judgment.
Apart from Arti Murmu.
No, I don't have any another judgment, only this one. So my learned friend has not, my lord, questioned that these two, the order single bench and division bench Supreme Court, is not applicable. He is arguing from the another point, but he has also accepted reply is not permissible, my lord. But he has argued, I have argued, he argued, I am reply. Again, he is to reply, he is to fill up his lacuna, it is not permissible.
You have raised the point that when there is presence of direct dependent, an indirect dependent cannot be taken into consideration for granting appointment. That is answering. Apart from that, nothing more.
But I think I'm not answering anything.
In the case law cited by my learned friend, only the employment was given in that case.
Yes.
Here in this case, no employment. That difference is there.
Senior counsel, you have submitted.
That my
During your normal submission, you have submitted that.
My lord, now, my lord, thing is, this judgment is, my lord, binding precedents. Your lordship knows that the coordinate bench is binding upon the order of.
Anything more to be submitted?
No more.
My lord, only the thing workman compensation only in case of
accident
or while on duty during the course of employment and died in harness, that is different. Died in harness may be outside the course of employment. But in the workman compensation, there will be death will be in during the course of employment. That is different during the course of employment.
You have raised this issue at least twice prior to this.
Sorry.
So your issues, two issues you have raised. One is when there is presence of direct dependent, no indirect dependent can be given appointment, and Workmen's Compensation Act comes into play in case of accident, and if death takes place within the preview of the the place of appointment.
Yes.
And whereas in case of this NCWA, NCWA comes into play when there is the employee has expired being in harness. This is the difference you have raised.
And another submission is in Supreme Court judgment in 2000.
But my argument has been accepted by the single bench.
That supports my view. That is my contention.
Heard the learned counsel representing the petitioner in full, and the learned counsel representing the opposite party, Coal India Limited, elaborately. Full stop. Arguments concluded. Reserved for judgment.
Get full. My audience will continue after my recess.
No, second half to appellate.
My lord, in the meantime, written
Original side.
convenience written submission can be given.
Save it.
For the convenience of the honorable court,
Yes, short
written
matter, my lord.
submission can be given in the meantime.
When can you provide?
Within 7 days, my lord, 1 week.
Well, 4 dates are there.
কি বলেন নেক্সট তাহলে
মানে
1 মিনিট নেক্সট আজ কত তারিখ আজকে 19
Because
26 তারিখ ছুটি 28 তারিখ খোলা আছে so it will be on 28th under the heading to be mentioned.
Yes.
The parties are at liberty. ঠিক আছে আগেরটার মতো
grateful, my lord. Grateful.
But judgment reserve kindly, my lord, mention. Otherwise, in case if it is, my lord, change, we will file.
Yes.
But kindly mention the argument complaint judgment reserve.
জাজমেন্ট ইজ রিজার্ভ থাক রইলো জাজমেন্ট রিজার্ভ রইলো আর 28th for filing written notes of argument if any.
If any. Only, my lord, indicate the judgment, my lord, the judgment. Very well. Very well.
My lord. Grateful, my lord.
Judgment is reserved হলো তো আর the parties are at liberty to file written notes of argument if any on 28th. On
My
28th.
junior will be there, my lord.
Anybody
My lord.
only on that day there won't be any
Yes, my
verbal
lord.
submission
Yes, yes.
accepted, only written notes of argument
Yes, ma'am.
on
Yes.
28th. অ্যাপেলেট সাইড তো অ্যাপেলেট সাইডে কি আছে কি লিখেছে দেখে নি ক্লারিফাই করে নি
আছে আরো আছে অরিজিনাল সেট আছে তো অরিজিনাল সেট আছে আরো
আছে আজকের এটা আজকেই তো মনে হচ্ছে 19th আগস্ট স্যার এখানে কেন আজকের তারিখ সবই ঠিক আছে এখানে 10:30 কেন করেছে আমি বুঝতে পারছি না 10:30 করে দিয়েছে সেকেন্ড তো কিচ্ছু দেওয়া নেই taken up first thereafter after some will taken up from the list complicated করে দিয়েছে after completion of original side matters appellate side matters will be taken up লেখা আছে তো?
Possibly, today is whole day or something.
চেঞ্জ করতে হবে আজকে কি করবো আজকে পরিস্থিতিটা কি করবো
It is written in the original side list. After completion of the original side, appellate side will be taken up.
but appellate side matters are also there
But in the original side, it is written that the after completion of the original side matters, appellate side matters will be taken up.
গন্ডগোল হয়ে গেছে কি করা যাবে বলতো? From 2 p.m. Learned Council, appellate side matters will be taken up. এটা একটু ক্লারিফাই করে দিতে হবে এই রেকর্ডিংকে হ্যাঁ 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 or earlier ওটা ক্লিয়ার করে দিতে হবে
Appellate side.
From 2 p.m. appellate side matters
Very
will be
well.
taken up.
67 of today's list. And it's a very urgent matter. My lord, this instant civil division will become infructuous. The suit is at the stage of final arguments. My lord,
on two dates, the entire list was called. At that time, nobody was found
my lord,
to move.
my lord, there was
So, whatever may be the urgency, it cannot be upgraded now.
my lord, there was a resolution. So there cannot be a stay order passed. That's why it was not moved, my lord. Because of the
What prevented you from being present?
my lord, stay is required because the case is at the final arguments. The instant civil division will become infructuous. In a case, my lord, 2 written statements are filed.
I'm not going into the merits now, Lord Counsel.
My lord, the next date fixed for hearing is in August, 7th August, my lord.
7th August of 2026 have passed by.
No, my 7th September.
7th September. It will be taken up prior to that. Today is only 19th of August.
My lord, kindly give some preference.
No.
Lordship, may I please be permitted to mention one matter? Mentioning for inclusion in the list.
Second appeal or civil revision?
It's the CO.
CO, civil revision.
Number 1.
It's that matter, my lord, your lordship directed us to come.
Petition.
But that's enhancement of element, yes.
By the directed last occasion to produce the income document.
Oh, okay. Enhancement one, not that incorporation of the person from as appellant, not that one.
No.
Yes, you have to provide that the father is not bearing the 50% expense of the child. You have to provide those documents.
These documents, my lord, although my lord, I have been told by my client, my lord, these documents through Firisti we have already handed over to in the court below also, my lord. I am also handing over here and now again, my lord.
Application
It take to Didi.
Application.
For the
just to remind your lordship, just for your lordship's information, after this order impugned passed by the learned trial judge regarding the rejection of their prayer to enhance the alimony pendentility, there was a application moved before the learned trial judge asking that yes, same thing which has been repeated by before your lordship, that the father is not bearing the entirety of the 50% of the expenses. This is the application which they have filed. Why, I am suggesting this, subject to again correction by your lordship.
This is the order.
This is the order which has been passed pursuant to this application.
Under section 151.
Yes, my lord. If this order is not being challenged before your lordship, perhaps, my lord, subject to correction, my lord, today my learned friend cannot again, my lord, repeat and reiterate the same issue which has once been raised, adjudicated, and rejected by the learned trial judge.
Okay.
And he has not challenged that order also.
This 151 petition has been filed on 24th of June 2026.
Yes, my lord. And your lordship, I have handed over the order before your lordship.
Order dated to
Order dated 13th of
July.
Yes. In that order, if my lord kindly sees, second paragraph also, they have given an undertaking that they will pay the balance amount. It was their undertaking also, my lord.
So where is the violation pleaded? Because today, my learned friend cannot, my lord, ask your lordship.
In between the quarrel, let me interrupt. Wherein?
No.
Which portion are you placing?
In that order, which
Yes,
is
yes,
that learned advocate for the petitioner husband raised objection. He has submitted that this is a dilatory taxing on the part of the respondent wife. learned advocate has given an undertaking the petitioner husband will pay the balance amount which is due to pay within this day.
That has been paid on that day itself.
Is my instruction, my lord. Upon documents also, that has not been fully paid.
So then he has to challenge this order, or he has to approach the learned trial judge for that. But we all know, my lord, these orders are executable orders. In this guise, my lord, he has challenged in the present revisional application only with regard to his, my lord, prayer for, my lord, rejection of his prayer for, my lord, enhancement. This inquiry, my lord, subject to again, my lord, today, my lord, from the bar, he will say not pay, I will say pay. This will be again material evidence to be placed. And I have been told, my lord, this firisti which have been handed over before your lordship, this has been submitted before the learned trial judge after disposal of this application.
Impugned order.
Impugned order as well as this order.
This one also.
So this firisti was not even there before the learned trial judge when, my lord, this has been, my lord, this order has been passed. My lord, kindly see the date of the firisti. Firisti's date is, my lord, submitted on 11th of August 2026. Today, my learned friend has handed over before your lordship the bunch of documents. This firisti has also been filed before the learned trial judge after this.
I am not on the issue, my lord. I am on the...
No. You have, after raising the issue,
no,
you
I
are
am
saying that you are not in the.
I am not, since my lord,
Not be learned
since my lord
this is not at all appreciated.
No, I am not on that issue. Kindly allow me for 1 minute, my lord. Since my lord on the last occasion.
Why 1 minute? You are being allowed for half an hour.
Okay.
You can submit, but submit to the point.
Since my lord on the last occasion directed me specifically to produce documents, I have produced these documents. It was on their part to produce the income certificate here.
I am carrying that. I am not.
Let him place the income certificate, details.
And, my lord, also the chart, my lord, I have prepared.
1 minute, Lord Counsel.
Yes,
Mr. Mukherjee.
Very well. My lord, let him complete.
Place the bunch of documents. What you have.
Now it will be very difficult for your lordship, my lord, since this was not made in a proper manner, my lord. I have made a year-wise segregation, which I am handing over it to your lordship, my lord.
Yes.
To Deven, Didi.
No, you have mentioned here in date of expenses.
Year-wise kore punch. Kindly sees, my lord, year-wise, my lord. It is second year hostel and mess fees amount so and so, tuition fee so and so. With documents, annexing the documents, my lord. Thereafter, paper seeing, revaluation. Now, my lord, kindly comes to the third page of that bunch, which I have handed over here now.
What is paper seeing, Lord Counsel?
That was university. That is
this is not involved in the list. But what is that?
But that
paper
is,
thing?
I am not well aware.
The answer scripts, the answer to show the answer scripts.
No, probably certain project preparations.
My lord would find everything, my lord. It's a very arm twisting. My lord, my lord, there are
nowadays some development has taken place
yes,
in
that's
institutions.
True. That's true. That's true.
When we were studying, these things were not there. For paper seeing, rupees 300, rupees 200.
So that was the expenses borne by the mother for the education. If my lord goes
so
to
the lump sum is second year hostel and mess.
But kindly comes to third page, my lord. Third page, page 3.
Yes.
The total educational expenses
490.
50% goes amount to this amount 2,45,000. Now kindly sees the payment by the father.
So according to you, 50,000 is remaining to be paid
for this second year. For second year. Now kindly comes to third year. Kindly comes to page 4. The total education expenses
365.
No. Page 4, my lord, 5,67,795. 50% is 2,83,000. Page 4, my lord.
Yes, page 4.
Total education
At the top.
yes, total
It's
educational expense
5,67,000.
55% is 2,83,000.
Father was to bear
50%.
2,83,000.
Yes, father has paid 2,02,000.
Acha. Remaining is 18 year, about 80,000.
Yes. Now, my lord, kindly 4th year. Kindly sees is the 4th year, my lord, I have handed over.
1 minute. To 50,000. Next one.
4th year, I have handed over.
4th year.
Kitchen.
Deal. Second year, 3rd year.
4th year. Page 3, my lord.
Yes.
Page 3, my total educational expenses 4,55,000. 50% amounts comes to 2,27,000. That he has made 2,12,000.
Learned Counsel.
My lord.
In addition to that, why have you mentioned jewelry sale by petitioner?
No, that
defendant?
I have to pay to meet up the expenses.
Why have you mentioned in here jewelry
Kindly,
sale by
kindly that was it was kindly ignored that.
ought
portion.
not to have been mentioned.
Yes, kindly ignored, my lord. Those are
So 15,000.
yes, for the 3rd year. These are the total dues till date, my lord.
Yes. Anything more?
These were the.
Mr. Mukherjee.
Yes, please.
They are claiming second year 50,000 remaining to be paid. 3rd year 81,000 and 4th year is 15,000.
My lord, this adjudication was that's why, my lord, I handed over before your lordship the chart. My lord, kindly takes up this. My lord, this is the
Whatever is being provided, let it be provided. A copy be provided to the adversary.
the chartটা যেটা জজ সাহেবকে দিয়েছি। My lord, the 2nd, 3rd, and 4th year, my lord, whatever amount that my client has paid, that, my lord, is, my lord, mentioned over there. My lord, your lordship will get, my lord, 6,10,000, I believe. That has already been paid on account of 50% of, my lord, the education expenses. Now, this issue was raised, my lord, before the learned trial judge, and by order number 113, the learned judge has dealt with the matter, and their prayer, my lord, why, my lord, I am mentioning this before your lordship, because the entire endeavor of the, my lord, wife is to stall the proceeding. Why? Lord, it started in 2014. Today we are in 2026. When there was a specific direction passed by this honorable court to dispose of the suit, at that threshold, this 151 application was filed before the learned trial judge, asking that please stay the all further proceeding of the suit in view of non-payment of this. The learned trial judge dealt with that issue, my lord, in order number 113. There was a direction, or rather my client's, my lord, undertaking through his advocate that whatever the dues balance, that after adjudication by the learned trial judge, that has to be remitted on that day itself. My lord, the remission was there ultimately on that day through NEFT. 1,56,610 rupees was remitted, my lord. I have the NEFT with me. The issue has been closed there. Today again, on a roundabout way, before your lordship.
On which date it has been paid?
My lord, it is on 13th of July 2026 itself.
Same day.
Yes.
13th of July.
The amount has been remitted to the wife's account. That order, my lord, again in my respectful submission, neither, my lord,
1,61,000.
1,56,610 rupees on that very day, my lord. And had it been a case after that remission, there remains anything due, he ought to have either, my lord, prefer a recalling application before the trial court or challenge that order. Neither these two has been, my lord, seen the light of the day. My lord, it's a ploy, my lord. I am telling your lordship, being an officer of the court, it's a ploy, my lord, 2014 to 2026 only to, my lord, delay the hearing of the suit. And I have, my lord, shown, I will not repeat, my lord, in reply. I have already shown before your lordship, 2014, my lord, the lady was happy with 10,000. First enhancement, 14,000 in 2019.
That has been submitted.
And the conduct has been, my lord, gone down by the learned trial judge, has gone down, my lord, in his impugned order. What is the conduct and why, my lord, the learned judge is refusing this at this threshold, at the time of continuation of argument, this prayer for enhancement? And your lordship knows, my lord, under Article 227, even if the two views are available, if the order is not perverse, the interference will be much lower. Here, my lord, by detailed analysis, the learned judge has dealt with the matter. This is, my lord, my submission, my lord. I'm great.
With regard to my lord, one reply, my lord.
Last
Last occasion, my lord has directed to produce the income document. That is not it been done. This is not, probably this is not the income document.
No, okay, income.
Yes, yes.
দেখাবে?
হ্যাঁ, clear. And my lord, I am not such a father that, my lord, I am taking the ground that my child has grown up, 18 years gone. By this passage of time, your lordship seen 6,10,000 and thereafter 1,50,000. So it gone down to 7 lakh, almost 8 lakh. I have paid. The requirements cannot be, my lord, fanciful. After deduction, my lord, it has been mentioned, the net pay.
Yes, 1,92,994, not 65,000. Probably they all along,
income is 65,000.
probably all along it was their submission that they have been earning 65,000.
If my income is 65,000, can I bear
92,000?
such a
They should be coming clean hands before the court will also saying that they are earning 1,92,000.
That's why I've been able to pay 50% of my child's expenses.
Kindly seize, my lord. All along it is there that 65,000, even the recalling application which was filed, they have stated on oath that they have
every month, my lord, I have to spend at least 70,000 out of my this income towards wife and my child.
They are not doing any charity to them.
I am not saying that. I am not.
You did, there are dues, my lord.
I'm grateful. I'm grateful.
Learned counsel representing the petitioner wife has produced documents in support of his contention reflecting the expenses for the second, third, and the fourth year of the BTech course of the child. Full stop. Those be kept, no, those be kept to the record. Full stop. On behalf of the opposite party, husband, a document revealing net income, net monthly income has been produced wherefrom it is revealing that the net monthly income is 192,994. It is revealing that it is rupees 192,994. Let those be kept to the
And
record.
the chart of my expenses, that's
On behalf of the husband, another chart has been provided.
the last payment has not been mentioned over there, that NEFT one I have told before your lordship.
No, no, আছে, আছে।
আছে?
আছে,
NEFT
আছে।
আছে? ও, তাহলে ঠিক আছে।
Even in my document also, I have given that document, which I have received.
ঠিক আছে, ঠিক আছে।
Details of 50%.
Yes, details of 50% according to my client. NEFT the last one, the
1,56,000.
1,56,000.
Yes, yes.
Even in my bunch of documents, I have also stated so, my lord. In fourth year, my lord, if my lord kindly sees, on 13/7/2026,
That day on which the order was passed.
Let those documents be kept to the record. Arguments completed. Reserved for order. এটা কি বলে এই যা ডকুমেন্ট এই সব ডকুমেন্ট এক্ষুনি ওই এনভেলপে ভরে দিন, বুঝেছেন? এনভেলপে ভরে এর সাথে আজকেই পাঠিয়ে দেবেন।
I'm grateful. Extremely grateful.
Document number 2 and 3.
I'm for the opposite party in both. But I'm for the petition. Which naam koreli.
Well, there are two civil revisional applications.
Yes. Yes, Lord Counsel.
Yes. Well, two civil revisional applications are there, my lord. Lordship kindly takes up, my lord, firstly, 1513 first, my lord.
1513.
The second one is, my lord, from a connected application, my lord, your lordship, my lord, decides 1513, my lord. The second one will be, my lord, automatically, my lord, covered. May I just, my lord, indicate the facts? My lord, I am the judgment debtor. In respect of, my lord, the execution case that is going on. Now, my lord, the execution case, which is, my lord, numbered as title execution case number 5 of 2013, that is arising out of a title suit, my lord, being 190 of 1995.
Title suit 190
of 1995. And my lord, out of that, my lord, the title execution number 5 of 2013 arises.
Yes.
Now, my lord, this suit was, my lord, decreed ex parte on 15th of January 2009 against me, ex parte against me and others.
List of dates are required.
My lord, that's it, my lord. And no more dates, and one more date would be relevant, my lord. This is the date, and another date would be relevant.
Decreed ex parte on
15th of January 2009.
Yes.
Well, 3 or 4 dates, my lord, would be relevant. Your lordship will find it, my lord, from the short list of dates, my lord, at the start of the revisional application, my lord. After the synopsis, the short list of dates is there.
Yes.
Now, my lord, what has happened is, my lord, out of that, a miscellaneous case number 98 of 2013 has my lord arisen for my lord police help, my lord, lordship knows, my lord, a separate miscellaneous case is registered. Now, my lord, while this miscellaneous case
number
98 of 2013
98 of 2013 for police help.
For police help. Filed by them, the decree holder. Now, my lord, what I have done is, my lord, I have taken out an application during the hearing of the miscellaneous case, my lord, that one of the defendant being defendant number 6, died, my lord, prior to passing of the decree. The decree was, my lord, passed on 15th of January 2009, and I filed an application that the defendant number 6 expired on, my lord, 13th of February 2003. 2009 the decree was passed, 2003, my lord, she died.
Bindubala Mondol.
Bindubala Mondol.
She was the
defendant number 6. And, my lord, since, my lord, the decree has been passed against a dead person, my lord, I say that the decree is a nullity, and unless it is corrected, the decree cannot be executed. So the execution case ought to be stayed for the time being. That is what my sum and substance my application is, my lord. Kindly see, my lord, how the learned court has dealt with it, my lord. It's, my lord, order number 129 dated, my lord, 18th of October 2023. Well, today is fixed for hearing of the petition dated such and such. Both the parties file hajira. Now the petition dated 6th of September 2023 is being taken up. The petition dated 6th of September 23 is a stay petition prayed by the petitioner. Learned advocate for the petitioner has stated that defendant number 6, namely Bindubala Mondol, had expired on 13th of February 2003. And the defendant number 8, namely Montu Dhali, expired on 5th of June 2019. My lord, 5th of June 19 is, my lord, after, my lord, passing of the decree. So, my lord, I am not, my lord, although, my lord, steps are to be taken in the execution process, still, my lord, it's after the decree, and steps can be taken, my lord, during the, my lord, in the ongoing proceeding. But the suit, title suit number 190 of 1995 was decreed ex parte on 15th of January 2009. Thus, the suit, title suit number 190 of 1995 stands abated. This is where, my lord, probably, my lord, the learned trial court has, my lord, recorded wrongly my submission, my lord. It should be, my lord, decrease a nullity since it's against a dead person. That is what my sum and substance of my argument is, my lord. Learned advocate for the defendant has raised vehement objection to it. At this stage, the court finds that title suit number 190 of 1995 had already been decreed ex parte in the year 2023. My lord, this should be, my lord, not 23, my lord. This should be, my lord, 2013 probably, my lord. 2009. 15th of January 2009, my lord. Decree, my lord, the date has been, my lord, mentioned wrongly. It should be 2009. The petitioner, oblique judgment debtor, had come before the court to abate the ex parte decree. At this juncture, the petitioner judgment debtor had no locus standi to make such a prayer before the court, as title execution number 5 of 13 has already been stayed, and in this case, there is no question to pray for abatement of an ex parte decree. There is no provision in the CPC for abatement of an ex parte decree. Hence, the application is rejected. My lord, kindly sees, my lord, what my sum and substance of my application is, my lord, that a decree, my lord, passed against a dead person cannot be enforceable. There are, my lord, two persons who have died, my lord, one prior to, my lord, passing of the decree, and subsequently another who had, my lord, passed in 2019 after, my lord, the decree was passed during the execution process. Therefore, my lord, steps are to be taken in respect of both. In respect of, my lord, the first person who died in 2003, my lord, the decree is, my lord, non-enforceable at all. Cannot be enforced since, my lord, that person died, my lord, prior to passing of the decree. So far as the second person is concerned, my lord, the decree holders, they had to take steps, my lord, for, my lord, impleting his legal heirs, my lord, for substitution and all the other, my lord, formalities. My lord, kindly, my lord, I am relying, my lord, upon a decision of the Honorable Apex Court, my lord. Really, Lordship, really. My lord, kindly, my lord.
No. First refer the citation.
Yes, my lord. Citation is, my lord, this is 2017, volume 13, SCC 414. Kindly sees, my lord, that I'll just, my lord, indicate the paragraph number, my lord. It's primarily, my lord, 16 to 21, my lord. Paragraph number starts from paragraph number 16. The effect of, my lord, passing a decree against, my lord, a dead person. My lord, may I read from 16 onwards, my lord? I'm, my lord, reading. It is not in dispute that the appellant and two respondents expired during pendency of the second appeal. It is not in dispute that no steps were taken by any of the legal representatives representing the dead persons and on whom the right to sue has devolved to file an application under Order 22, Rule 3 and 4 of the CPC for bringing their names on record in place of the dead person to enable them to continue the lease. The law on the point is well settled. On the death of a party to the appeal, if no application is made by the party concerned to the appeal or by the legal representatives of the deceased on whom the right to sue has devolved for substitution of their names in place of the deceased party within 90 days from the date of death of the party, such appeal abates automatically on expiry of 90 days from the date of death of the party. In other words, on 91st day, there is no appeal pending before the court. It is dismissed as abated. Order 22 has been quoted, my lord. I'm going to, my lord, paragraph number 19. In the case at hand, both the aforementioned provisions came in operation because the appellant and two respondent expired during their pendency of the second appeal and no application was filed to bring their legal representatives on record. As held above, the legal effect of non-compliance with Rule 3 and Rule 4.3 of Order 22 of the CPC came into operation, resulting in dismissal of the second appeal as abated on expiry of 90 days from 10th of May such and such. The High Court therefore ceased to have jurisdiction to decide the second appeal, which stood already dismissed as on such and such date. Indeed, there was no pending appeal on and after such and such. And, my lord, kindly, my lord, takes up 21, paragraph number 21. It is a fundamental principle of law laid down by this court in Kiran Singh case Supra that a decree passed by the court, if it is a nullity, its validity can be questioned in any proceeding, including in execution proceeding or even in collateral proceedings, whenever such decree is sought to be enforced by a decree holder. The reason is that the defect of this nature affects the very authority of the court in passing such decree and goes to the root of the case. This principle, in our considered opinion, squarely applies to this case because it is a settled principle of law that the decree passed by a court for or against a dead person is a nullity. Therefore, my lord, I am questioning, since, my lord, admittedly the decree was passed, my lord, after since, my lord, admittedly, my lord, the decree was passed, my lord, after, my lord, the defendant number 6 expired. The date of expiry is, my lord, 2003. The passing of the decree is in 2009. Therefore, my lord, my humble submission would be that this decree would be not enforceable, my lord. Steps are to be taken, my lord, to rectify the same. And till that point, my lord, I have prayed for a stay of the decree since, my lord, execution proceeding was going on. The learned court has, my lord, categorically held that I am praying for abatement, and if it is an ex parte decree, no, there cannot be any abatement. Where from, my lord, the learned court has, my lord, got this, my lord, theory, my lord, is, my lord, unknown to me, my lord. My lord, I am questioning, my lord, myself, my lord. The abatement, my lord, abatement is a natural process of law, my lord. It cannot depend on, my lord, whether a suit is running ex parte or not. If no steps are taken, it will automatically abate. Even, my lord, no application for abatement is to be filed. That is what, my lord, the law of the land is, my lord.
So you are not aggrieved by the first portion that is already stayed. Title execution 5 of 2013 is already stayed.
My lord, I'll just 5 of 2013. I'll just indicate what happened, my lord. Here also, my lord, the recording is wrong. What happened is, my lord, kindly take some, my lord.
No. That counsel. Whether this one is correct or not. At this juncture, the petitioner judgment data has no locus standi to make such prayer before the court, as title execution 5 of 2013 has already been stayed.
Wrong.
Is it so?
No. My lord, kindly, my lord, takes up page number 10. What happened? Page number 10, my lord, is an order of this honorable court. In a parallel proceeding, my lord, this honorable court was approached with respect to, my lord, that execution proceeding. And this honorable court stayed that execution process in the execution proceeding in respect of one dag only, my lord. Kindly see page 10. Page number 10, my lord, has been filed. The petitioner here is also, my lord, the same petitioner, my lord, who has filed this revisional application. Kindly see, my lord, I'm reading for your lord. No, my lord. No, my lord. He is, my lord, for the learned advocate.
Oh, sorry.
My lord, Shunil Kumar, one Shunil Dhali and Sushil Dhali. They are also the petitioners in the. Your lordship will, my lord, get the cost title, my lord. It's annexed, my lord. Page 8. Page 9, my lord, is the name of the petitioners.
Shunil and Sushil.
Shunil and Sushil, my lord. Kindly see, my lord, what happened in, my lord. Why this revisional application was negotiated. The present revisional application has been preferred by the judgment debtors in a decree of declaration and permanent injunction in respect of several plots, including the dag number 440. By virtue of the impugned order, the executing court refused to stay execution in respect of such ex parte decree, passed in title suit number 190 of 1995, well, the same title suit, during pendency of a subsequent suit, being title suit number 165 of 2012. Therefore, my lord, these two petitioners, the same petitioners, they have filed another suit, being number, my lord, 165 of 2012, where they have prayed for that earlier decree is not binding upon me. And they also prayed, my lord, for stay of the previous execution proceeding, which the learned trial court refused. Against that, my lord, this revisional application was preferred. The learned advocate appearing on behalf of the petitioner submit.
Why another suit was filed?
Well, that order was challenged. That decree is not binding upon me. As such, my lord, the second suit was filed. The learned advocate appearing on behalf of the petitioner submits that the petitioners confine their prayer for stay only to dag number 440 and are for the present not concerned with the other plots which are subject of the decree passed in title suit number such and such. The learned advocate appearing on behalf of the opposite parties on the other hand submits that since the opposite parties are enjoying a valid decree, the judgment debtors petitioners ought not to disturb the possession of the decree holders in respect of all the plots which are part of the decretal property in garb of execution of the decree in question. It appears from the materials on record that the present judgment debtors have filed a subsequent title suit being number 165 of 2012 in respect of several plots, including dag number 440, which was part of the decretal property in title suit number 190 of 1995. Since a question of fraud has been raised in the said subsequent suit, it would serve the ends of justice if the execution pertaining to the decree passed in title suit number 190 of 1995 is stayed for the time being only in respect of dag number 440, which the petitioner restrict their prayer. Accordingly, the revisional application being number such and such is disposed of by modifying the impugned order to the extent that there will be stay of title execution case number 5 of 13 pending before the learned civil judge junior division Haldia, the same execution number, only in respect of 440. So, with respect to 440, my lord, the execution is stayed. With respect to, my lord, the other tags, my lord, the execution proceeding is going on, my lord. That is what, my lord, the sum and substance of this order was. My lord, what I have raised, my lord, in this subsequent application is, my lord, a technical question, my lord. But I say, my lord, that one of the defendant died prior to passing of the decree. So the decree which was passed is a nullity, and that decree cannot be enforced altogether. Therefore, all the proceedings arising out of that decree, which includes an execution proceeding and another miscellaneous case, my lord, the instant miscellaneous case, those ought to be stayed till, my lord, that point of time, till, my lord, proceedings are initiated. Now, this is, my lord, the first revisional application. The second one is, my lord, a strange one. What the learned trial court did, my lord, was subsequent. This order was passed. After that, this order was communicated to the learned trial. Stay was obtained by us. While moving, my lord, this revisional application, a stay was obtained by us, my lord, from the single judge. This order was communicated, my lord, to the learned trial court. The learned trial court held that title.
Ultimately, there is order of stay.
Yes, my lord, in respect of this revisional application, we obtained an order of stay of the execution proceeding. And that's.
So there is stay of the execution proceeding.
Right now.
Right now.
Right now, my lord. After this.
In respect of the entire title.
In respect of entire execution.
Title execution.
Entire execution, my lord.
There is stay.
That is with respect to this revisional application, my lord, not with respect to, my lord, the previous revisional application, my lord. While, my lord, admitting this revisional application, this honorable court, my lord, was pleased to grant an order of stay of the entire execution proceeding. That was, my lord, that was, my lord, communicated, my lord, to the learned trial court. What the learned trial court did was hold that the honorable high court has only stayed the execution case, not the miscellaneous case. So I am entitled to move ahead with the miscellaneous case.
Miscellaneous case is arising out of the.
That is what. Kindly sees, my lord, the last order
of title execution.
Yes, my lord. To
you.
Yes. My lord, and that is what, my lord, in the last order, my lord, the Honorable Justice Basu, as his lordship then was, my lord, taking up the matter, my lord, directed, my lord, that the miscase should be stayed along with the execution. My lord, made the order, my lord, clarify that portion. That when you stay the execution proceeding, the miscase ought to be stayed. That is, my lord, the sum and substance of the second revisional application. But, my lord, the first revisional application is the more pertinent one, my lord. If that is, my lord, disposed of, the second one, my lord, can easily be, my lord. Analogously, my lord, can be disposed of altogether.
No, you have submitted that in respect of only DAG number 440, there is order of stay. Later on, you have submitted that there is order of stay in respect of the entire title.
I'll, my lord, clarify. In respect of DAG number 440, this High Court was pleased to, my lord, pass an order of stay in CO number 3633 of 2016.
3633.
That is, my lord, that stay is valid since 2016 altogether. With respect of 440. While this impugned order was passed, and we preferred, my lord, the present revisional application, and his lordship, my lord, Justice Basu was, my lord, pleased to, my lord, admit this revisional application. He was pleased, my lord, to stay the entire execution during admission of this. As such, my lord, as of now, my lord, after the admission, that is, my lord, from 2024 onwards, as of now, my lord, the entire execution is stayed. In entire execution.
So, neither the title execution nor miscase arising out of that is proceeding.
Is proceeding. That is, my lord, subsequent to this revisional application.
State.
State, right now.
Yes.
That is my sum and substance.
The entire was stayed wide order.
During admission of this revisional application, my lord. I'll just, my lord, try and indicate, my lord, the date, my lord. Yeah. My lord, it's, my lord, probably, my lord, 7th of August 2024, my lord. My lord, can I have the file once, my lord? I'll just take it out.
Second,
Didi, ekbar diya. My lord, 14th of August 2024, my lord, kindly seize, my lord, the order, my lord. It's a bit, my lord. Justice Basu, my lord, as his lordship then was, my lord, directed the registrar, my lord, to get a show cause, my lord, from the learned presiding officer, my lord.
CPC রে দৌড়ে নিয়ে আসুন CPC বইটা নিয়ে আসুন দিয়ে দিচ্ছি
Yes, Mr. Poddar.
So I am replying first CO 1513. And kindly come to the order impugned. Order impugned is order dated order number 129, 18th October 2020, 18th October 2023. Today is fixed for hearing of petitions dated 6th September 23. Both parties filed Hajira. Now the petition dated 6/9/2023 is taken up for hearing. The petition dated 6/9/23 is stay petition prayed by the petitioner. Stay petition means the JDR. JDR. Learned advocate for the petitioner has stated that defendant number what was their contention by filing so many CO, another suit, another proceeding, praying for abatement. What is the main claim? Now it is learned advocate for the petitioner has stated that defendant number 6, namely Biduwala Mandal, had expired on 13th February 2003. And defendant number 8, namely Montu Dhali, had expired on 5th June 2019. Well, very well, true. But the suit TS number 190 of 1995 decreed on 15th January 2009. True, correct, accepted. Thus, the suit of title suit number 190 of 1995 stands abated. It was their prayer. And prior to 15 January 2009, decreed passed ex parte. Ex parte. It is not contested that this is defendant never come forward before the court below to contest the suit. Supreme Court judgment, many judgment, all on every proceeding ex parte. There was no opportunity of the opposite party to submit. Now let me complete the rest portion. Ex parte decree. During the pendency, the some of the defendant died who were non-contesting. I am coming later on the provision of 22 of the Code of Civil Procedure, 22 Rule 4. An advocate for the defendant has raised vehement objection to it. At this stage, the court finds TS 190 of 1995 has already been decreed ex parte, and in the year 2000, it is 9. Wrongly, it is typed 2023. The petitioner judgment letter had come before the court to abate the ex parte decree. At this juncture, the petitioner judgment letter had no locus standi to make such prayer before the court, as title execution 5 of 2013 has already been stayed in view of the order of this court. And in this case, there is no question of to pray for abatement of an ex parte decree. There is no provision in the CPC for abatement of an ex parte decree. Well, it is very vital, very significant. There is no provision in the CPC for the abatement of an ex parte decree. Hence, it is that the petition dated 6/9/2023 is hereby considered and rejected on contest without cost. So, my lord, from this impugned judgment, it is evident that decree was passed ex parte. So, that the deceased defendant who, despite service, choose not to appear, not to contest in the suit. It is admitted one from the judgment and from the submission advanced from the petitioner judgment letter side. Now, your lordships, kindly consider Order 22, which is very much relevant in order to adjudicate the present dispute. Order 22(4), Sub-Rule 4. We need not go through the Supreme Court judgment. We need not go through any judgment passed by this honorable court in connection to the present dispute.
Yes. Mr. Poddar, you are referring to
Order 22,
Rule 4,
4, Sub-Rule 4.
Sub-Rule 4.
4.
Yes.
May I read, my lord?
Yes, yes.
The court, whenever it thinks fit, may exempt the plaintiff from the necessity of substituting the legal representatives of any such defendant who has failed to file a written statement or who, having filed it, has failed to appear or contest the suit at the hearing, and judgment may in such case be pronounced against the said defendant, notwithstanding the death of such. So here the case is 2003 death, but suit is of 95, summons served, no appearance, no written statement, no contest. The deceased defendant were nowhere in the picture of the suit. If in such circumstances, substitution of the legal representative of the defendant will not be attracted, plaintiff will be exempted. Here it is the provision says that court, whenever thinks fit, may exempt the plaintiff from the necessity of substituting the legal representative of any such defendant who has failed to file a written statement or who, having filed it, has failed to appear. Here, failed to appear or contest the suit at the hearing, and judgment may in such case be pronounced against the said defendant, notwithstanding the death of such. So, where the court below committed error, where the court below committed illegality, nowhere in the proceeding, there are two proceedings before this honorable court, but nowhere it was disclosed that it was a ex parte decree, and there was no scope on the part of the opposite party decree holder to ventilate the real picture or to interpret the order 22 rule 4 sub-rule 4. For that reason, the court says, and not only that, my lord, in the said proceeding they filed one miscase praying for abatement. That is here, which my learned friend has not divulged before this honorable court, that ex parte decree, one suit, independent suit, no result. From that suit, there was no result from staying this decree. Till today, the decree has not been stayed. And against ex parte decree, no order 9 rule 13 at the instance of the heirs of the deceased defendant. Now, my lord, kindly see the ex parte decree itself. My lord, I don't know whether there is any copy of the ex parte decree dated 2009. আছে কি তোমরা দিয়েছো? দাওনি না? পাওনি? Well, kindly have a look. And I would also rely on Solenama.
No. First, you refer to that ex parte decree judgment.
Lordship, kindly peruse it. I have only one.
Yeah.
Kindly see. Kindly see. A 2-3 pages judgment. I am searching Solenama. There is a Solenama.
পাখাটা বন্ধ করে দেবেন। পাখাটা বন্ধ করে দেবেন।
Yes, I have. My lord, kindly see from page 2, last paragraph, PW1 and PW2 corroborated the plaintiff case in material particulars. The DS record marked Exhibit 1 reflects
Not DS, either it will be CS or RS.
a district survey or district survey. That is written in the court record. A district survey. It is mentioned here. Anyway, it is one survey record.
It can be either CS
or RS.
or RS.
My lord.
Cadastral or revisional.
Reflects that Nitai Dhali was absolute owner of scheduled property.
Nitai Dhali was the grandfather of these
Yes,
persons.
a main ancestor.
Grandfather.
Yes. This is the, my lord, kindly see the genealogical table I have.
Yes, the genealogical table.
Kindly have a look. Yes. Yes, it is Joseph ke din to. My lord, there is some sketch mark, my lord, excuse me, my lord.
Let a copy be provided to them.
কপি তো ওর কাছে থাকে নেই তুমি দেখো কোনো প্রবলেম নেই
Nitai Dhali.
হ্যাঁ let me complete this expertise decree.
One minute. Okay.
My lord, page 3, that the genealogical table and the evidence of witnesses on oath shows that plaintiff had 1/6 interest in the suit land. Admitted. Further, some of the defendants filed a solenama. My lord, I am coming with the solenama. Some of the
TS 190 of 95 is a partition suit.
No, it is a suit that admittedly this plaintiff are the owner in respect of 1/12 portion of the property left by Nitai Dhali. No dispute as per inheritance. Now, what happened, my lord? This Malati Devi, who, my lord,
Mr. Poddar, one thing. TS 190 of 95 is a suit for
declaration.
Only
Declaration that for correction of record of rights in the record, his name disappeared because her name disappeared because she relied on some other legal heirs of Ananta Dhali, or they are the defendant. I am coming to that. My lord, it is more fully mentioned in the plaint itself. They, my lord, did not incorporate the name of this Malati Dhali. For that reason, her name was not, her predecessor, her husband's name was not recorded. Her husband's name was not recorded in that record. I am coming to that plaintiff specific. So, for correction, that is error, and that is by fraudulent practice of the defendants, some of the defendants. So, this was done, and during the
what is the name of the husband of Malati Dhali?
Malati Dhali is, my lord, I am coming, that is in the plaint. Basudev Dhali. My lord.
Basudev. Yes.
Basudev Dhali. My lord, so my lord, one solenama by the legal heirs from this branch. They filed this along with genealogical table and admitted, yes, it was out of omission. The name of Basudev Dhali was missing from the record of rights, though he is entitled to 1/12 of the share of the property left by Nitai Dhali. This is the sum and substance. So, my lord, when, my lord, one of the two legal heirs preferred solenama, admitting the claim of the plaintiff, so matter sorted out there. Now, my lord, kindly see, they are resisting me for execution the same, and so that I can rectify, I can put my name in the record of rights and corrected the record of rights. They resorted this practice that one such defendant died, never uttered. It is ex parte decree, never uttered, they never appeared. So, in view of Order 20T, Rule 4, Sub Rule 4, this is, my lord, This is redundant. Whoever death, alive, well, sorry. If my lord, a non-attending defendant dies, no matter at all. So no question of my lord substitution. We know very well.
So you are relying upon order 22 rule 4
For sub-rule 4, simple. We know the decree against a dead person is a nullity. But when ex parte, it is not applicable. When they are not taking, when they are not in the fray.
Anything more? Any other point?
Only this is the point, and here are my lord. I am showing my lord Solenama, my lord, once, my lord. It will be more clear. It will be more clear. So yeah, my lord, kindly see. So the decree was the suit was decreed in 2009. So my lord, they can, my lord, file order 9 rule 13 in order to, my lord, setting aside the expiry decree. There was nothing, nothing is pending, no order 9 rule 13 as of today. One separate suit, my lord, in that suit there was no stay, nothing of sorts. So my lord, they filed this 1513. Thereafter, my lord, in order to make a hodgepodge before the court below, my lord, they one after another they filed application. My lord, kindly see in 1513, there is in page 14, there is a miscase praying for abatement. That was taken up by the court below. It is not police help. J miscase, it is praying for abatement. So court below, this honorable court say that will be stayed till the disposal of this 98. My lord, your lordship find it page 14 in 1513.
Yes, I have found it, but place the relevant paragraph.
Abate Parthonai Dorkhasto, lordship's got it.
Yes, I have got the application.
Yes.
Relevant.
So this is
place the relevant paragraph.
No, I am just wanted to submit. This is registered as J miscase 98, and this hearing was taken on by the court below. And this argument was advanced, but they
through this application, what they are trade.
My lord. Sunil Dhali রে দেনাদার গণের নিবেদন এই যে judgment data শ্রীমতী মালতী ঢালি
you place paragraph number 6 অতএব প্রার্থনা যে paragraph number 6
প্রার্থনা যে 6 নম্বর বিবাদিনী শ্রীমতী বিন্দুবালা এবং 8 নম্বর বিবাদী মন্টু ঢালি বিন্দুবালা মণ্ডল এন্ড মন্টু ঢালি পরলোক গমন করায় 190-95 নম্বর মোকদ্দমায় অ্যাবেট হইয়াছে। টাইটেল এক্সিকিউশন 5 of 2013 ও জে মিসকেস 98-13 নম্বর মোকদ্দমায় অ্যাবেট হইয়াছে এই মর্মে আদেশ দিতে দেওয়া হোক। So my lord, this petition was taken up for hearing through, my lord, your lordship knows that the abatement issue it is registered as a miscase, and in that miscase, my lord, evidence was adduced. It was at the argument stage, which your lordship will get it from the another CO, connected CO. Yes. 2814. My lord, kindly come to the impugn order. Impugn order is, my lord, 22nd July 2024, and before that there are 3rd July order. Let's kindly have a look. Today is fixed for argument. You also got it?
3rd July.
3rd July. Today is fixed for argument by the petitioner. Petitioner means that the Denadar, JDR, who filed application for paying for abatement. Both parties filed Hajira. Today, that is 3rd July 2024, learned advocate for the petitioner has filed a taken off petition along with a stay petition. They are also taken off. Then they don't want to complete the same, to dispose the same. The taken off petition is allowed on contest with a cost of 600 to be paid by the petitioner, not paid. Learned advocate for the petitioner files photocopy of the order of the Honorable High Court, Calcutta, in respect of CO 1513/2024. Let it be kept with the record. It can be derived from the order of the Honorable High Court, Calcutta, that there is no stay order in respect of J. Miss case 98 of 2013. The Honorable High Court, Calcutta, direct this court to stay the proceeding of execution. Well, only execution. If there is a connected miss case, execution is the finality. The connected miss case can be proceeded with. That is, and the court below was proceeded with their 47 application. Execution case 5, title execution case number 5 of 20 has already been stayed by the court by order such and such till disposal of the J. Miss case 1998. So, J. Miss case from this sentence till disposal of 98 of 2013, the title execution case should remain stayed. That means that J. Miss case is under section 47 by the judgment debtor. It's clear, no ambiguity. Learned advocate for the petitioner submits before this court that the court can pass order as per wish of the court. It is their submission. The petitioner had not concluded his side, conducted his side of argument, or not advance. They even not advance argument. So before this honorable court, they are saying the court is erred by not staying the miss case, title execution case, as well as J. Miss case, such and such. So the court below violated the Honorable High Court's order. So in fact, J. Miss case is for prayer abatement, my lord. So it is very much incumbent upon the executing court to dispose of that plea by the judgment debtor. But the judgment debtor here, they are not disclosing what is J. Miss case for, 98 is for. They want, I compel to say this word, they misguided this court.
Counsel, Mr. Poddar, once you are saying that judicial miss case is under section 47 of the Civil Procedure Code.
Yes.
While on the other hand, you are saying that judicial miss case is for abatement.
It is for abatement.
No, why have you said that?
My lord, from this line, kindly see. From this line.
That you have placed, that paragraph.
That is somewhere, my lord, the code.
Paragraph 6 you have placed.
Yes, and here, my lord, here, order dated 3rd July.
So why have you said that judicial miss cases are under section
47? So, my lord, from here, my lord, from here, 3rd paragraph, 4th paragraph, the order dated 3rd July. 3rd July order, which I just referred, just traveled in. The Honorable Court, Calcutta, has directed this court, well, got it?
Yes.
To stay the proceeding of title execution case 5 of 2013. That was remain stayed. But title execution case 5 of 2013 has already been stayed. It is a version of the court below. No dispute. By this court, by order number 106, dated 27 January 2021, till disposal of J. Miss case 9813. So till disposal, it must be of others, not the decree holder. It is simple understanding. These miss case may for what, and this miss case of whose, until disposal of 9813, title execution remains state. That means it is not not filed by decree holders. And if it is for police help, that should not be that sentence.
So according to you, judicial miss case 98 of 2013 is
Their plea. They are 47. I refer that petition in 1513. Now, my lord, kindly come. This gone.
No, that is through that they have sought for abatement.
Yeah, abatement. Abatement at the instance of
Why are you saying 47?
abatement, praying for nullity. At the same time, they say it is nullity. Since it is abated, there is also nullity. My lord, here it is.
Where is that you are placing that application?
অতএব,
No. Where is that application?
This is
That's,
page 14 of the 1513. অতএব প্রার্থনা যে 6 নম্বর বিবাদী শ্রীমতী বিধুবালা মণ্ডল এবং বিবাদী মন্টু ঢালি পরলোক গমন করায় 1995 মোকদ্দমায় অ্যাবেট হয়ে যাচ্ছে।
It is abatement প্রার্থনার দরখাস্ত।
Abatement.
Yes.
Oh, abatement.
Why are you bringing section 47?
So it is abatement. So abatement. So now, my lord, kindly turn that page. Now kindly to order impugned in second CO 22nd July. Today is fixed for further argument and payment of cost.
You are referring to CO 28114. Order dated
22nd July.
July.
The impugned,
22nd July.
impugned hearing.
22nd July.
Today is fixed for further argument and payment of cost of rupees 600 by the petitioner. By the petitioner means my learned friend's client. Both parties file hajira. Petitioner again files the order of the Honorable High Court, Calcutta, in respect of CO 1513-24, on the basis of which it has already been ordered by this court, vide order number 137, dated 3rd July 24. That is a staying of title execution case. An advocate for the petitioner submitted before this court that he has nothing to say in this case except the order of this honorable court. Nothing to say except order of this honorable court, wherein title execution 5 has been stayed. He said nothing to say.
Yes.
It is the version where they prayed for abatement.
Let us proceed.
An advocate of the petitioner submitted argument on behalf of the opposite party had already been closed. Today on the part of the petitioner is closed. On both parties closed. 278 for passing final order on payment and payment of cost 600 by the petitioner. So this is the order impugned in this CO. So what wrong here the court has quoted? What wrong, what illegality the court below committed so that it can be assailed by this CO? It is my question to myself. What is the wrong in it?
Anything more to be submitted?
My lord. Huh? Let me show that Solenam. My lord, main thing is, my lord, order 22.
Yes. Fulcrum is that one. Why are you proceeding?
Plus, that is, they are harping on that Moraloker name decree. A decree against a dead person. But ex parte decree when order 22 rule 4 sub rule 4 my lord erase all the argument on behalf of the petitioner judgment debtor. There is nothing remains. One CO, second CO, there are as many as 3 COs.
Court is not concerned.
Why not? I am deeply obliged.
1,000 COs.
I am deeply obliged. I am squarely relied upon order 22 rule 4 sub rule 4 in this case, and they also admitted that when they died, they also admitted the expiry decree. So in expiry decree, more whether he alive, whether the defendant non-contesting defendant alive, living, or go to abroad, no problem. The court exempt the plaintiff from substituting that order under order 22 rule 4.
Yes, Mr. Poddar is relying upon order 22 rule 4 sub rule 4.
No, I would like to show your lordship that a solenama I am not. It is missing from my record now. It is there are solenama. Solenama was, my lord, executed by the father of the present petitioner, my lord. Who are the present petitioner? Sunil Dhali and another.
What will be the effect herein?
No. So who are disputing? Whose father was executed a solenama? I'm searching it. I am sure if it is. তুমি বলো reply দাও. আমি দেখছি.
It is in his brief.
Which one?
Maybe in his brief.
My brief, well, there's nothing. Well,
So it was.
well, my brief, well, lacks that.
Must be
Well, my brief,
executed
well, does
by
not,
their
does not
predecessor.
contain the decree, does not contain the plaint. No, it cannot be, my lord. Since it has been, my lord, exported throughout. My lord, may I, my lord, also rely on order 22 rule 4 sub rule 4?
Order 22 rule 4
Sub rule 4. My lord, may I rely on that? My lord, kindly, my lord, takes up, my lord, the order 22 rule 4, my lord, sub rule 4. The
Yes, solenama. Well, I got it. Solenama. It was in different file.
You go through it twice. Yes.
My lord, kindly takes up, my lord, that provision, my lord. The court, whenever it thinks fit, may exempt the plaintiff from the necessity of substituting the legal representatives of any such defendant who has failed to file a written statement or, having filed it, has failed to appear and contest the suit at the hearing, and judgment may in such case be pronounced against the said defendant, notwithstanding the death of such defendant, and shall have the same force and effect as it has been pronounced before the death took place. Now, my lord, kindly considers whether, my lord, this exemption is automatic or, my lord, it is discretionary or it has to be, my lord, expressed. My lord, this exemption cannot be automatic. My lord, the very language is the court whenever it thinks fit. So there has to be a, my lord, of application of mind by the honorable court that I do not think that this substitution is necessary in this instant case, and I exempt the legal heirs from being substituted. In the instant case, my lord, the fact was, my lord, for the first time put before the learned court that this particular defendant has died prior to filing of the suit, my lord, prior to, my lord, passing of the decree. And one of the defendant has died after passing of the decree during the execution proceeding. Therefore, if the court thinks it fit to exempt the legal heirs of those two defendants from being substituted, the honorable court, my lord, has to pass a reasoned order, has to, my lord, consider the submissions, pass an order according to that, and exempt the legal heirs from being substituted. What is, my lord, the impugned order in the instant case? Yes, my lord, kindly cease. In the instant case, my lord, the learned court, my lord, says absolutely unreasoned, my lord. The court, my lord, goes on the fact, my lord, that I try to abate it. Kindly, my lord, says that there cannot be abatement of an ex parte decree. There is no provision in CPC for the said abatement of an ex parte decree. Hence, the application for stay is rejected. First of all, my lord, the honorable court, my lord, during taking up the stay application goes to the merit, my lord. Even, my lord, leaving that aside, my lord, if the court feels, my lord, that exemption, I am willing to apply my power under order 22 rule 4 sub rule 4 and exempt from those different, from the legal heirs from being, my lord, being substituted. There has to be an express order of that. My lord, there are, my lord, judgments, my lord. I just found out, my lord, I'll, my lord, produce a copy of those judgments, my lord. Lordship, my lord, kindly keeps it on to be mentioned any day. My lord, produce the judgments. No, judgment, though, sir. Judgment. Order 22 rule 4 express. My lord,
What he is saying, my lord.
No, no, আমি স্যার শেষ করিনি
in a
স্যার শেষ
proceeding
করিনি
of
স্যার শেষ
what
করিনি
one-
শেষ করিনি স্যার
There are several dependent. Maybe if if anyone died, my lord, during the pendency of the expertise proceeding against them,
At
my
the
lord,
time,
how
learned counsel, he will be producing a citation, one or maybe two, maybe two.
let him.
You will get the opportunity because at the stage of reply, he is producing the same. So you will get the opportunity to contradict that.
But I still, my lord, or 22.
Yes,
Sub-rule
you are
4.
relying upon.
Bas.
Acha, in that circumstance, have you gone through the Solenama? What were
Yes,
what
yes.
were you what? So you intend to file one authority.
one of the
One authority.
on the fact, my lord, that if the court, my lord, really, my lord, has the intention to exempt the substitution,
A reasoned order has to
a
be
reasoned
filed.
order and a reasoned order, and that exemption cannot be, and the exemption can be discretionary, but it has to be recorded.
Reasoned order has to be passed.
And my lord, one of the striking feature, the deceased defendant.
No, okay, Mr. Pottar, you place that Solenama?
Yes. মালতী ঢালি বাদী ও মানিক ঢালি।
Copy, my lord. Otherwise, my lord, I am, my lord, very less equipped, my lord. May I get a copy?
তোমরাই তো করেছো এটা।
সেটা হয়তো 100 বছর আগে হয়তো।
I'll get it Xerox and
Let everybody fair.
my lord, আমি বাদী, আমি 2 নম্বর বিবাদী, আমরা পরপর নিকট আত্মীয় হইতেছি, আমাদের উভয় পক্ষের মোকদ্দমা খরচ সাশ্রয়ের জন্য মোকদ্দমার ফলাফল অনিশ্চিত জানিয়া আমাদের উভয় পক্ষের হিতৈষী পঞ্চজনার আপোষ মীমাংসা মতে আমরা উপরোক্ত নম্বর মোকদ্দমা নিম্নলিখিত মতে সোলেনামা করিয়া লইলাম। আমি বাদী ও আমি 2 নম্বর বিবাদী। Well, kindly see who is 2 নম্বর বিবাদী।
My lord, kindly considers one aspect, my lord. The subsequent suit is, my lord, pending for that reason, my lord, that the previous decree is not, my lord.
No matter.
Yes, certainly it matters, my lord.
You may file hundreds of.
Here cannot be a trial, my lord, going on, my lord, at the instance of my learned senior friend, my lord.
What he is saying.
A trial is being, my lord.
আমি বাদী ও 2 নম্বর বিবাদে আমার পরপর একমত হইয়া স্বীকার করিতেছি ও সহমত হইতেছি যে অত্র সোলেনামা একটি অখণ্ড চুক্তিপত্র ও ইহার প্রত্যেক সত্য অপর সত্যের মূল্য হইতেছে। অত্র সোলেনামার সময় এসেন্স অফ কন্ট্রাক্টস হইতেছে।
Time is the essence of contract.
হ্যাঁ, আমি 2 নম্বর বিবাদী অঙ্গীকার সহকারে ক্রমশ প্রকাশ করিতেছি যে নালিশি ভূমি বাদী ও বিবাদী গণের পূর্বাধিকারী নিতাই ঢালির 3 পুত্র কৃষ্ণ, ভগীরথ ও অক্ষয়ের তুল্যাংশে প্রাপ্ত সপ্ত দখলি সম্পত্তি ছিল। কৃষ্ণ গত হইলে তাহার ত্যক্ত অংশ ক্রমশ ওয়ারিশ সূত্রে 11 নম্বর বিবাদী প্রাপ্ত হইয়াছে। আমি 2 নম্বর বিবাদী অঙ্গীকার সহকারে আরো প্রকাশ করিতেছি ভগীরথ।
2 নম্বর বিবাদী is মালতী।
2 নম্বর না, plaintiff is Maluti. 2 নম্বর বিবাদী is my lord. They are petitioner's legal predecessor, father. 2 নম্বর my lord, 2 নম্বর ভাগ্যধর মানিক ঢালি। আমি 2 নম্বর বিবাদী অঙ্গীকার করিতে আরো প্রকাশ করিতেছি ভগীরথ।
Mr. Poddar, you provide a copy of the Solenama
Yes.
to them also during the course of this day?
My lord, and my lord, kindly have a look, my lord. Here, my lord, Bhagarath.
You have 2 copies?
Their signature is appearing, and this is the part of that decree.
Do you have 2 copies?
No, I'll get it Xerox, no problem.
Provide one to the court.
এটা দুটো করবেন তো, হ্যাঁ?
And to them one copy to the court and one
copy একটা দেবো, একটা ওকে দিয়ে দেবেন।
Then, my lord, also allows me to, my lord, produce the copy of the subsequent plaint, my lord. I have to, my lord, get that, my lord, copy, my lord. Otherwise, because my lord,
Plain.
if that issue is devolved upon, my lord, if
No,
that-
I
পরেরটা,
I am
subsequent.
I am ready to provide you anything you want which is under my custody.
When to be kept?
My lord, if my lord, this is relied upon, my lord, I have to also rely upon that subsequent
This is
plane.
an expert degree.
Subsequent plane, my lord, I have
Part
to
of
rely
the
upon.
decree.
When to be kept? When to be kept?
Kindly, my lord,
So
give
তুমি
just
judgment-
7 days time. Otherwise, only if the judgment was the only concern, my lord, tomorrow it could have been kept. If my lord, the documents are to be gone through, my lord, then my lord, 7 days time is my lord required.
My lord, give him no problem. My lord,
Factual aspect will take
is-
more time.
it is.
than
My lord,
legal
no, my
aspect.
lord, the procurement of those documents, my lord, would take my lord the time. My lord.
I have no problem. My lord, you lost your hard it
Which date? Which date to be
as
kept?
per his
On
convenience. My
consent-
lord,
on
kindly kept it
on
as per
consent of both sides.
as per his convenience.
Kindly, my lord, keeps my lord any day, my lord, next week, my lord.
Kindly mention the date so that no.
My lord, next Thursday, my lord, because Wednesday, your lordship, my lord, generally takes the my lord original side in the first of my lord. Next Thursday, my lord.
27th.
Thursday week. my lord.
27th.
No problem. My lord, top.
No, okay. Acha. So it will be taken up. কেন 27 তারিখ কিছু আছে at the top কিছু আছে 27 তারিখ দেখে নিন তো। আচ্ছা দিদিমণি
আমাকে লালবাজারে ছুটতে হবে।
And my lord, may I, my lord, also come back with a notes of argument on that day, my lord?
10 তারিখ
If your lordship, my lord, once that, my lord, otherwise,
তুমি করো।
very precise, my lord. 2 pages. Within a page, my lord, might be difficult.
I will only.
Certainly, on
I
that
will,
day.
only, my lord, subscribe the order 22 rule 4 sub rule 4. Nothing more. Nothing more. I have no.
Grateful, grateful.
Let,
Everything,
let,
everything.
my, let my learned friend be satisfied with his counseling. No problem. Yes, yes.
But one would be sufficient, my lord.
না না দুটোই করো আবার ওটা একটা রেখে দিয়ে লাভ কি আছে?
Yes, the petitioner in both the petitions.
There was another which was disposed of.
No, no. Oh, the 2016, that's on a completely different footing altogether. Yes, yes, there are also number of suits filed by them.
No, no, no.
I need to give a list now, my lord.
হ্যাঁ আমি জানলাম এটা একটু আসলে পাওয়া যাচ্ছে।
The learned counsel representing the petitioners submits that he intends to provide judgments, 2 judgments. He
One I have
intends to-
already, my lord, provided. But on this point, my lord, that order 22 rule 4 is not, my lord, automatic. It has to be expressed.
he intends to আচ্ছা কি বলে এটা না লাস্টে করে দিন বুঝেছেন he intends to provide one judgment in respect of order 22 rule 4 of the sub rule order 22 rule 4 of the code of civil procedure full stop ঠিক আছে এর আগেই ঢুকিয়ে দেবেন যে ওই যে যখন submission of the learned counsel representing the opposite parties while arguing on behalf of the opposite parties, the learned counsel has placed, not raised, PLACED placed order 22, rule 4, sub rule 4 of the code of civil procedure. ঠিক আছে? ব্যাস। হ্যাঁ। civil procedure ঠিক আছে হয়ে গেল এবার on consent paragraph in such circumstance the hearing is deferred further hearing is deferred let the matter appear on 27th of August. Part heard. 27th of August at the top.
At the top. Grateful.
কি বলে শুনুন, এই যে লুজ যেগুলো থাকবে না সবকিছুকে কিন্তু ওই এনভেলপে দিয়ে দেবেন, ঠিক আছে? এটা এটা একটু এটা ওই আপলোড হয়ে গেলে না একটু পাঠিয়ে দেবেন, আপলোড হয়ে গেলে। দেখুন next. Neither the petitioner nor the petitioner nor the opposite parties are being represented. File tag to them are being represented in such situation. The matter cannot be proceeded. Let the matter appear on 25th last কোন অর্ডার আছে এই বেঞ্চের অর্ডার নেই, এটা ফার্স্ট টাইম তো। Let the matter appear on 25th of August. না ঠিক আছে, অর্ডার নেই যখন, অর্ডার থাকলে দেবেন, কিন্তু ফাইলটা দেখে নেবেন আছে কিনা। নেক্সট
Number 5.
ফার্স্ট টাইম আসছে তাই তো, সেম অর্ডার। ওই আইটেম নাম্বার 4 এ যা অর্ডার হলো আইটেম নাম্বার 5 এও সেম অর্ডার, 25th এই আসবে।
Item number 6.
Lordship, item number 6 and item number 7 are my applications, Your Lordship. Lordship, appear for the petitioner. Lordship, the only difficulty is I'm a bit handicapped right now because I'm not being able to contact the clients, Your Lordship. I was humbly praying if Your Lordship would kindly keep both the matters in the monthly list of October or anytime as Your Lordship pleases. I'll need to take instructions, Your Lordship, to continue with the matter, Your Lordship.
Monthly list of
October or September, anytime Your Lordship pleases.
কোনো অর্ডার নেই তো দুটোতেই, ওই 6 আর ওই যে কত যেন পরের দুটো
Item 6 and 7, Your Lordship.
6 and 7. The learned advocate representing the petitioners seeks an accommodation. Full stop. The prayer for accommodation is granted. Let the matter appear on 3rd of September. Let the matter appear on 3rd
Grateful.
of September.
Grateful, Your Lordship.
Item number 8.
My lord, I beg to appear for the petitioner in this matter. Yes, my lord, at this stage it is a new motion application, my lord. I am challenging, my lord, an order passed on 19th of September 2025 by the Civil Judge Senior Division at my lord Alipur, wherein my lord and
বলছি যে ওই যে দড়ি দিয়ে বাঁধতে বারণ করবেন, ওই সাদা যেটা বাঁধবে একটু বড় দিতে বলবেন, একদম ছোট্ট দিচ্ছে গিট করে বড় দিতে বলবেন, ঠিক আছে? Yes.
wherein my lord an application under Order 40 Rule 1 in a partition suit, my lord, has been allowed. And my lord, I am assailing that order, impugned order, my lord will find. My lord, the basic ground upon which I am challenging this order is, my lord, violation of equity, doctrine of equity,
Order dated
19/9/2025, my lord. There is, my lord, if I subtract the period of permissible as per limitation, my lord, only 40 days delay. I have explained it in paragraph number 16 and 17. And if my lord sees annexure H, my lord, the medical reports have been annexed, my lord.
annexure.
Annexure H, my lord, annexure H, page 120. Impugned order is at, my lord, 19/9/25. Date of filing of this application is, my lord, 27th of January 2026. Total time period is, my lord, 130 days. Limitation period 90 days. If I subtract it, my lord, there is a delay of 40 days only. My lord will see from annexure H that the time period for procuring the CTC, certified copy, for 8 days, that has also been subtracted. 32 days, my lord. In that time period, my lord, he was entirely ill.
Suit for partition.
Suit for partition. And, my lord, the basic...
Counsel, let the other side appear.
Definitely, my lord, but in short, my lord, let me initiate the basic crux of the case. That is, my lord, the issue is initiated in the year way back in 1992. The property upon which the partition has been sought for.
You serve.
My lord, my lord.
Photo item number 2.
আমার নাম জানিস? এখানে appear only.
The impugned order is dated
19/9/2025.
19/9/2025.
The reasoning, my lord.
Why have you provided the entire order sheets?
My lord, I have provided the entire order sheet. It is annexed separately, and the impugned order is separate, my lord. The entire order sheet is, my lord, is at... Yes, my lord, the entire order sheet has been annexed, and the impugned order, my lord, will find at the last, my lord. It is like
2025.
7 pages prior, 19/9. And, my lord, the relevant portion is, my lord, the...
Any other application has been filed?
No, my lord. No, my lord. And, my lord, the reasoning, my lord, will find in the second page of the impugned order, internal second page of the impugned order, the last paragraph. Perused the petition, WO and relevant documents as filed by the parties, it appears that admittedly OS 4 of 1991 is pending before the Honorable High Court. I am in view, though OS case is pending, yet there is no bar to appoint a receiver to preserve the suit property and collect the income from the suit property. That is, my lord,
the suit property consists of?
My lord, the suit property is basically belonging to my grandfather's estate. He died through a will, my lord.
Consists of?
Consists of land, and some portion there is a school, a small school, which was established and run by my mother, who is one of the beneficiaries in that will. Now, my lord, the executor who was appointed in the will was not executing the will. Therefore, my mother came up with a LOA, letter of administration, and administrator was appointed. This administrator, my lord, was an advocate administrator. Thereafter, my mother filed another application for appointing a party administrator, and that is, my lord, this OS case pending before the High Court. Now, my lord, during pendency of that application, partition suit has been filed by the other party stating that there is no will. I can show it to my lord that plaint is also annexed. In paragraph 4, they are stating that Ardhendu Mukherjee died intestate. And they have already objected to that LOA.
Letter of administration has been disposed of.
Letter of administration,
It is not pending.
it is not pending. My lord, in the LOA, their predecessors have objected. They are much aware about the existence of the will. And thereafter, when the administrator was appointed, my mother filed another application because it was an advocate administrator. My mother was not challenging it. My mother has filed an application to appoint a party administrator. That is all, my lord, and that is still pending. Now, my lord, until and unless the will is being probated, my lord knows that after December 2025, there is no requirement for probating a will. Therefore, my lord, how the partition suit stands? Because if the will is decided, my lord understood.
The being aggrieved by and dissatisfied. আচ্ছা যেটা পিডে বলবো না আস্তে বলবো কোনটা পরিষ্কার বলবো being aggrieved by and dissatisfied with the order dated 19/9/2025 ধরতে না পারলে বলবেন আমাকে 19/9/2005 the petitioner or petitioners,
my lord, only one petitioner, my
the
lord.
petitioner has preferred the present revision application. Full stop. Two, the impugned order, date বলেছি না 19/9/2025, to the impugned order, actually an advocate, a learned advocate has been appointed as a receiver in respect of the two properties for protection, preservation and management of the suit property during the pendency of the suit, and the said receiver has been further directed to submit accounts on monthly basis. Full stop. The question for paragraph, the question which has arisen as to whether the appointment of the receiver is at all tenable or not.
My lord.
The present revisional application will be heard on this issue. Full stop. The opposite party or parties?
My lord, there are opposite parties, my lord.
The opposite parties, a copy of the revisional application be served upon the opposite parties. Full stop. Let the matter appear, and the petitioner is directed, and the petitioner is further directed to file an affidavit of service in this regard. Let the matter appear on, how much time will it take?
My lord, I can serve as early as possible, my lord.
How much time will you take?
Within 10 days, my lord. And my lord, there are like almost 15 respondents and 4 pro forma respondents. Should I serve upon the pro formas also?
Yes, upon all.
Okay. Then, my lord, I need at least 15 days, my lord.
Upon all the respondents, including the pro forma respondents. ঠিক আছে? To serve the copy of the revisional application be served upon all the respondents, including the pro forma respondents, including the pro forma PROFORMA pro forma respondents. ঠিক আছে? Let the matter appear and further directed to file affidavit of service. ঠিক আছে? In this regard, and let the matter appear 3 weeks. 26 to 9. 15th of September.
15th of September, fixed. Fixed on 15th of September,
Yes,
right?
15th of September.
Deeply obliged. There was.
Cabinet Council, Mr. Meghnad Datta has briefed the matter. He had a brain surgery, therefore he has request to item number 9 and item number 151, both.
You submit as regards to the item which has been called.
Number 9, my lord, he has request to fix the matter any day in the month of September.
Learned advocate representing the petitioner seeks an accommodation on the ground of the illness of his senior. Who is the advocate on record? You are the advocate on record. তাহলে advocate on record, ঠিক আছে? Advocate বলেছি তো? The learned advocate on record seeks an accommodation, ঠিক আছে? তার আগে learned advocate on record, শুধু advocate বলেছি প্রথমে? The learned advocate on record seeks an representing the petitioner seeks an accommodation on the ground of his senior, stating on the ground of the illness of his senior. Full stop. Full stop. And has sought for fortnight. Let the matter appear on eighth of September. দেখবেন ধুলো রয়েছে, ফাইলটা ধুলো।
Item number 10.
My lord, I am told that Mr. Shondip Das is in this matter for the petitioner. He is on legs in court number 5. I am praying for not today.
Not today.
May it please your lordship. So my application, the petitioner is the defendant. The petitioner is the defendant before your lordship in a suit for declaration and injunction. Now, what happened? The plaintiff previously had filed a suit being title suit number 56 in 1994 against my father. That suit ended in a compromise decree. Under the terms of the compromise decree, there were certain rights, obligations, and duties on the plaintiff and on us. This suit has been filed. This suit has been.
Suit was a partition suit.
It was a suit for declaration and injunction.
Declaration seeking?
Yes, it's a partition suit whereby I was allotted Schedule B property and the plaintiff was Schedule A property. So I am the owner of Schedule B property, plaintiff A. Now this suit, the plaintiff again files this suit complaining that I had been encroaching upon his property. The learned trial court.
Declaration and injunction has
injunction. Now, I'll show your lordship the nature of injunction sought and the suit filed. Now what happens? The trial court doesn't even bother to look at the compromise decree. It's a totally perverse order and passes a blanket order. Now see the admission on behalf. I'll just show two terms of the compromise and the admission on behalf of the plaintiff itself. If your lordship comes to the plaint, which is annexed at page 46, page 46.
Yes.
Now, at page 46 is,
It's a injunction application.
yes, plaint and injunction. There are admission in both the plaint and the injunction. Kindly come to the plaint first at 46.
46 is the injunction application.
Yes, 40. Oh, yes, 46 is the injunction. Yes. The Lordship will take the trouble to come to para 13 at page 51. Para 13 at page 51. Now, if your Lordship comes to paragraph 13, see the admission on behalf of the plaintiff. That thereafter the plaintiff, in terms of the sole decree in TS 56 of 1994, made plastering of his dwelling house at the extreme north building work and also painting his northern wall thereto by using temporarily the open land of the defense number 1 in TS 56 of 1994, having assistance of the defendant number 1. He has acted upon the compromise. Entire thing is completed. The wall, if your Lordship sees the map at page, can you see the map at page 33?
I think map ought to have been annexed with a plaint.
No, it is annexed with the compromise decree at page 33.
Yes.
At the northern port, this is the disputed area. This is the disputed area. This has been dismantled by the plaintiff himself. Nothing is there. It's not joint anymore. He himself admits that fact. And if your Lordship sees the compromise decree, kindly come to the terms of the compromise decree. That is at page 20.
Senate Council, this one is a common drain.
No, that's the common wall.
Common wall.
According to the compromise decree, that common wall would be taken down. 2 properties, I got Schedule B, he got Schedule A. The work is absolutely completed. Now what happens? Under the compromise decree, I can build my own building in that area. When I'm trying to build, he's a very vindictive person. He comes saying I have encroached on his property and he gets an injunction.
You are brothers.
No, not brothers.
Not brothers.
Not brothers. Now, kindly come to the, very interestingly, kindly come to the, before I go to the impugned judgment, kindly come to the prayer which he seeks.
No. Place the compromise.
Yes, compromise. 23 is there. Compromise petition is there at 23. Now,
this has been made a part of the decree. This has been made a part of.
Yes, exactly. This was overlooked by the trial court. Now, kindly see the compromise.
You are referring to
page,
internal page?
I am referring to internal page
3.
No, I'm referring to internal page 24.
No, okay.
Amicably, page 24, para 3. Amicably settled, decided finally on the following terms and conditions.
Internal page 24?
Yes. Oh, sorry, 24. This is, your Lordship will find, this is 23 is the compromise decree, which starts compromise petition.
So you are placing the second page of the compromise petition. Yes.
Second page. See the terms.
Paragraph 3.
Yes. Date of this suit has come and the contesting sat together and amicably settled, decided on the terms and conditions. Plaintiff is the absolute owner and occupier of the Schedule A property mentioned in the plaint and shown in the plan on his table. Defendant number 1 is the absolute owner and occupier of Schedule B property mentioned in the plaint and shown in the plan. Defendant number 1, for renovation and reconstruction of his old building, is entitled to demolish the old structures without causing any damages to the plaintiff dwelling house by any means whatsoever, subject to the condition as that the defendant number 1, after demolition of the old structure aforesaid, is entitled to raise or make new construction and be scheduled property as per sanctioned plan. And construction 1 shall be made by leaving 7 feet side space from the extreme northern boundary wall, a scheduled property running east to west only in front of 6 windows such and such, and the side space is to be kept open to the sky. The rest of the portion at B scheduled property, the defendant will make construction as per sanction plan, and the defendant number 1 need not leave 7 feet side space for the rest of the portion. That the parties hereby admit and confirm that the northern extreme wall of the dwelling and the plaintiff and the northern limit of the said northern wall on the ground level is the northern boundary limit of a scheduled property, is absolute wall of the dwelling house of the plaintiff and the defendant number 1 shall not raise any construction over B scheduled property within 7 feet, thereby infringing the plaintiff's right of enjoyment of air and light. And then the plaintiff will remove the old shed. So that is the plaintiff's portion. As far as I am concerned, it gives me an absolute right to make a construction. Now the plaintiff admits he has acted upon the terms of compromise. The said wall has been demolished with the help of the defendant. This fact was overlooked by the trial court. Now see the prayers made in the injunction application. Can it be granted? Before I go to the impugned order. Page 53.
1 minute. Page 53.
Yes, kindly see the prayers. I've never seen anything like this before. It is therefore prayed, Your Honor may be graciously pleased to grant an order of injunction restraining the defendant number 1 from demolishing the old joint 2-storied building at the A and B scheduled property. This is against the compromise decree and already been done according to the compromise, causing damages to the property of the plaintiff. And from cut out the joint building line and load-bearing building wall of 2-storied building. Residential houses exit since its construction at the B scheduled property, causing destruction and demolition of the 2-storied old dwelling and residential house of the plaintiff at Schedule A property, and from making obstruction to free air and light from the windows which exist at the northern building of the plaintiff, and from changing the nature and character of the suit property by causing damages to the property of the plaintiff, and from raising or making multi-storied building at the B scheduled property by demolition of the existing joint building and at the schedule B property adjoining to A scheduled property, and restraining the defendant number 2 from sanctioning the plan submitted by the defendant number 1 being BRC 53 of 2018-19, and from allowing the defendant number 1 to demolish the existing joint 2-storied building and B scheduled property adjoining to A scheduled property, and from raising new construction at the B scheduled property without leaving 7 feet wide space towards northern side of A scheduled property, and pass order to preserve the suit property during the pendency of the suit, and any delay may defeat justice, and an interim injunction of the above may be kindly passed and passed. I've never seen anything like this before. First of all, these are against the compromise decree. Second of all, as per the specifically fact, can you injunct an authority from passing a plan sanction?
What did the trial court do?
Trial court overlooked the entire compromise decree. Kindly see the findings. There's a question of law which I will argue. The trial court says
No.
64. 65, it starts at 65. Both sides filed Hajira today has been fixed for passing orders, and as such the record has been taken off for passing necessary orders. It is the case of the plaintiff that he is the owner of the property as described in Schedule A of the plaint, and defendant number 1 is the owner of B scheduled property. Plaintiff has claimed that TS 5694 had been filed by him earlier, which was decreed on compromise.
So the trial court has passed an order of status quo as
Yes.
regards nature, character, title and
Yes.
possession of the suit property as on this day. And what about the misappeal?
Rubber stamping it?
At this earlier stage, they consider primary and balance of payment. Question of issue of loss or injury, this political opinion, that's correctly.
The trial court has also said one thing, which is very, very, very much alarming. But now defense number is one is not willing to act on the same. He's trying to raise the trial court says that this is it says before grant of temporary injunction, the plaintiff was to establish a prima facie case. It is admitted case of the parties. It is admitted case of the parties that there exists a common wall.
Mini trial. You are referring to mini trial.
Yes, yes. This is where he goes wrong because I can show your lordship a constitutional main judgment.
Nil. When can you serve and come back?
I'll serve next week. I'll serve it.
What is the address?
Address it in Howrah.
Oh, that's... How many days? 1 week.
Yes, we'll serve it. Howrah, I'll serve on.
The petitioner has
No, we'll serve. No.
Petitioner being aggrieved by and dissatisfied with the order dated 7th of October 2024. 7th of October 2024. Passed in miscellaneous appeal 05 of 2019. Passed by the Civil Judge, Senior Division, First Court, Howrah. Thereby rejecting the miscellaneous appeal and affirming the order of status quo in respect of nature, character, title and possession of the suit property passed by the trial court in TS 899 of 2018 passed by the learned 4th civil judge. Insert passed by the learned 4th civil judge, Junior Division, Howrah in TS 899 of 2018. Full stop. There's arguable question as regards to the order of injunction. In such circumstance, the petitioner is directed to serve copy upon the opposite parties. Full stop. And to file an affidavit in this regard on the returnable date. Let the matter appear on 19-26. Second of September.
2nd of September. Very good. Lord, let the suit be stayed at least. No, I'm not asking for stay of the injunction order. Only the suit. Let the injunction be there, because otherwise they will proceed. And kindly notice one thing. It is admitted fact there exists a wall. Who has admitted? Plaintiff himself says it has been demolished.
Let them appear, that will be considered.
And this mini trial issue was considered in the Colgate-Palmolive case. Followed by a constitutional bench of this court saying, no, you can't say that. You have to look at the documents and then decide. Simply by saying a mini trial we will not do.
Next.
Wait.
নিয়েছেন কোন order? Neither the 12th, neither the petitioner nor the opposite party is being represented. In such circumstance, let the in such circumstance, let the matter appear. 27th of August 2026. প্রথম নিতে অসুবিধা হয়েছে? একটু টাইপ না এটা না সবকটা টাইপ করে কিন্তু পড়ে নেবেন একবার, তাহলে ঠিক বুঝতে পারবেন। নেক্সট। হ্যাঁ হ্যাঁ হ্যাঁ, শুধু অর্ডারের কপিগুলো, ফাইল পাঠাবার দরকার নেই, শুধু অর্ডারের কপি। আমাকে অর্ডার পাঠালেই হবে, শুধু তো ওই কেস নাম্বারগুলো ঠিকঠাক করে টাইপ করবেন, দেখে নেবেন, মানে টাইটেল সুট, মিসলেনিয়াস অ্যাপিল, যেটা যেটা আছে।
My lord, I am for the petitioner, my lord. My lord, order 1, rule 10 of the CPC has been denied by the learned court below. Now, my lord, I am the necessary party because, my lord, I am the co-owner. Now, my lord, lordship, kindly see the order, impugned order at last, my lord.
Dated 8/12/2025.
Yes, my lord, 8/12/2025.
Suit for?
Suit for declaration and suit for declaration and permanent injunction.
Have you filed the copy of the plaint?
Yes, my lord, at page 12.
Yes, suit for declaration permanent injunction.
The plaintiff is my brother, my lord. He has gifted a small amount of land against which he is also the owner. And he is asking for the declaration by filing the suit property to making other party leaving me aside. Well, I am the co-owner. Now, my lord, I have, my lord, at
No,
that point of time.
One minute. Schedule A is the entire schedule, entire property.
Yes, my lord.
No.
My
What
lord,
is this? What is
deed
this?
gift was at that point of time, deed gift was not there. That is why, my lord, I have annexed the deed gift by making the supplementary affidavit.
শুনুন, এটা লিখে নিন যে supplementary affidavit. The supplementary affidavit has been filed containing a deed of gift. Was it allowed earlier to file a supplementary affidavit?
No, my lord.
So,
My lord, at page 10, my lord, I have annexed.
Without
My lord, that is very much necessary for the real
it is very much
adjudication of the controversy, my lord.
necessary according to you, but you ought to have sought for leave prior to filing the supplementary affidavit. ঠিক আছে, থাক। Let it be kept with the record. Supplementary affidavit. Let the supplementary affidavit be kept with the record. Filed today, be kept with the record. Yes. Schedule A is the entire property.
Yes, my lord.
Measuring?
Measuring.
1 kata 15 chitaks.
Yes.
No.
And out of which, my lord, by the gift deed, 15 chatak 35 square feet has been gifted to me. By the.
According to you, the total property is 1 kata 15 chitaks.
Yes, my lord.
In respect of which?
My lord, schedule B, my lord, your lordship kindly see, schedule B. Schedule B is the my property. 15 chatak 27 square feet. At page 20, my lord. At page 20. All that piece and parcel of Bastu land measuring
So Muhammad Sayale, Sahel, and you are Muhammad Shams Badar Rizvi.
Badar Rizvi.
Rizvi. So Schedule B belongs to Mohammed Sahel.
I do not know, my lord, my lord. I have annexed the
This is from the
deed of gift. I have annexed. Lordship, kindly see.
You state the facts. You state the facts.
Your Lordship, kindly first, my lord, your Lordship, kindly see the impugned order. I'm reading, my lord.
Without
I'm reading, my lord.
facing the fact.
My lord, I have filed the order 1 rule 10 application. Then first I am come to order 10 rule.
Through the said application, you intended to be added as a party.
As a
Under
being
order 1 rule 10(2).
Being a co-owner of the property.
Being a co-owner of 1 kata 15 chitaks.
My lord.
According to you. That has been rejected.
That has been rejected, my lord. My lord, without giving me an opportunity of hearing. Only on the ground, my lord, that the name.
Now the fact is that.
Yes.
The crux is that whether you are a co-owner.
Yes, my lord.
In respect of that, what have you produced at the time of hearing of the order 1 rule 10(2)?
Yes, my lord. Your lordship kindly
Not
now.
Honored counsel, let me be clear.
Yes,
not now. At the time of hearing of the order 1 rule
page
10(2).
24, I have made the application at page 24.
Place the application.
That
relevant portion.
Relevant portion. That this plaint that paragraph 4, my lord, at page 25. That this plaintiff have gifted a land measuring about 15 chatak 35 square feet with a structure standing thereupon, situated in the suit property to the present petitioner by way of deed of gift dated 2/8/2005, and give delivery of possession thereof, and the present petitioner got possession and has been residing thereupon, and mutated his name in Kolkata Municipal Corporation. Now, my lord, that has been also annexed with the.
Was the said document produced at the time of hearing of the
Yes,
order
my
1
lord.
rule 10(2)?
Produced, my lord. At the time of hearing, it was produced, my lord.
Produced. 1 minute. It will reveal from.
Your lordship, kindly see copy of gift deed dated 2/8/2005 and copy of KMC tax receipt are annexed herewith as annexures.
Which paragraph?
4 paragraph, my lord. Paragraph 4, which I have read at page 25.
Copy of gift deed dated and copy of no. It is mentioned in the application.
Yes.
But in the impugned order, the petitioner claiming himself to be co-sharer and jointly possessing the portion of the undivided suit property which he obtained by virtue of deed of gift dated 2/8/2005.
Yes.
Executed by the plaintiff of the instant suit. The petitioner is in possession and mutates his name in the KMC record and enjoying the same by passing the petitioner thus prayed for adding him.
May I read, my lord?
So why it has been rejected?
Only because, my lord, the name, there is a spelling has been mistaken. Hamija and Hamja. Both father's name are same, address are same. Only the name Hamija and Hamja.
Plaintiff had gifted to you.
You. He is my brother. Plaintiff has gifted.
The plaintiff has gifted a land measuring about 15 to the present petitioner. Plaintiff is 1 minute. Plaintiff is Muhammad Hamja.
Muhammad Hamja.
What wrong the court has done?
Only, my lord.
What wrong the court has done? You go through the cause title, name of the plaintiff.
Muhammad Hamja.
Muhammad Hamja.
It has been filed by the plaintiff.
1 minute, 1 minute,
Yes,
1 minute. Son of
late Muhammad Maqbul Ansari.
Maqbul Ansari. Now place the deed of gift.
Muhammad Hamija,
Hamija.
son of Muhammad Maqbul.
Can we take into consideration Hamza and Hamija is same person?
No, my lord.
Acha,
Yes, my lord.
here in Hamza, here in Hamija,
Yes,
Hamiza,
Yeah, my lord.
son of, in the plaint it is late Muhammad Maqbul Ansari. And what is here in son of Muhammad Maqbul?
Address is same.
In one address, there may be thousands of people living.
Well, it is true, my lord, that he's my brother. Now, my lord, until
you
and
can
unless,
say,
my
that you
lord,
can say.
order 1, rule 10, my lord. My lord, what is the, my lord, if it should be allowed, ultimately, if I find no way, I shall be ousted, my lord. If I shall not been given an opportunity of hearing to substantiate my case before the court. Now, my lord, to this technical
minute,
point,
one
my
minute,
lord, I should be ousted from the court.
1 minute, 1 minute. You are Muhammad's.
Sams Badar Rijvi.
Where is the petition?
Sams Badar Rajvi.
Muhammad Sams Badar Razvi. Yes,
Page 12.
Son of Muhammad Maqbul. Yes. What is the schedule of the gift deed?
Schedule of the gift deed, my lord. Your lordship kindly see page 10. Page 10. Muhammad Hamza, son of Muhammad Maqbul.
Schedule of the gift deed, 1 minute.
Oh, schedule of the gift.
Parcel of plot of land, 15 chitaks, Bastu, comprised in part of Dag number 151. To the structure, I mean, the record RS Dag number 151 of Khotian number, where is Khotian? 100.
100.
RS sheet 32. Under KMC Garden Reach. Ward number?
Premises number.
At Jalia Para Road, Garden Reach.
Nadir, formally.
Municipality. Premises number Z3.
Yes, my lord.
Z3 by 103.
Jaliapara Road.
Z3 by 103K. And here in the suit property is Z3 103. Schedule of the plaint. Go through the schedule of the plaint.
Yes, my lord. Schedule of the plaint. My lord, the plaint has been filed by the plaintiff.
If the property in question is disputed,
my lord,
how can you be added?
My lord, your lords, my lord, I am requesting to your lordship, my lord, making submission. This technical point, my lord, if I shall not been given even a 10 minutes or 20 minutes to satisfy the learned code below, how can I establish these all things, my lord? At the first stage, my lord, it's a very much difficult to give the answer to all this question. Now, my lord, what is the wrong, my lord, if I shall be given?
On the note, herein it is Muhammad Shala. In the plaint, land and structure of Muhammad Sayale. On the south, house of Muhammad Hamza. On the south, in the gift deed.
Yes, sir.
Butted and bounded. On the south, it is land and house of Muhammad Hamza. And in the plaint, in the schedule of the plaint, on the south it is Jeliapara main road.
My lord,
If you are not a necessary party,
Learned
counsel, one minute. If you are not a necessary party, why the court will allow you to be added as a party?
May I submit one thing, my lord, most respectfully. My lord, can I give the full hearing of this court, my lord? Can I?
Yes. Of course.
My lord, this is not a court of hearing, my lord. It's a court of record. Your lordship kindly see, in order 1 rule 10, even Honorable Supreme Court has said the liberal approach will be given at least an opportunity should be given to the party. If I shall be not there, I shall be ousted.
But if
if I shall not given an opportunity of hearing to substantiate my case at the first instance, if I shall be disallowed to appear before the court, how can I establish my case, my lord?
one thing.
My lord, most of the things are similar.
Learned counsel, you will have
Suppose,
to
my lord,
prove-
something has been your query is, my lord, very minoritely your lordship query is. I shall give the all answers before the court of law by preparation. But the thing is that, my lord,
Prima facie-
name are same, my lord.
Learned
Address
counsel-
are same, my lord.
Learned counsel, prima facie you will have to prove.
I have
Prima facie you will have to prove that you are a necessary party.
Prima facie is, my lord, he and me both are the.
Because I'm stating this from the gift deed. On the south, it is land and house of Muhammad Hamza. On the south of the scheduled property mentioned in the gift deed. Do you have the copy of gift deed? Do you have a copy of the gift deed?
Yes, I have minutes in the supplementary affidavit.
No, go through that butted and bounded zone. On the north, it is Muhammad Salah. Let us take into consideration SALAH and SAYALE are same. That will have to be anticipated. Both are same. But on the south, it is land and house of Muhammad Hamza. Whereas in the plain, on the south, it is Jeliapara main road.
So, my lord, that was the land of Hamza.
On the south of the property gifted, it was the land of Muhammad Hamza. In the plain, it is mentioned that the on the south of the shoot property is Jeliapara main road.
I do not know, my lord. My lord, I am requesting your lordship, kindly allow me to contest. At the first stage, if I shall be disallowed, I shall be disallowed. I can do nothing. My lord, most of the things your lordship is finding that most of the things are similar to that. I cannot establish my case before the court of law by using
two things, Learned Counsel.
Yes.
Maybe that in the schedule of the plaint, in the schedule A of the plaint,
Yes, my lord.
What is mentioned in as premises number? What is mentioned as premises number?
Premises number, my lord, Z3/1/3. 103. Z3/103. Jeliapara Road.
Z3/103.
Yes,
and
ma'am.
the gifted property is Z3
Yes.
by 103
Yes.
by K for Karnataka.
I cannot improve my case after that one. Only I can request your lordship, and I can submit to your lordship. Your lordship may kindly allow me to substantiate my case over there. If I shall fail, I shall be ousted.
If there is a prima facie case, then it can be
prima facie too much what I have said before your lordship.
From that, prima facie does not appear. That is the question.
In the gift deed,
property
in the gift deed, name of the plaintiff as well the name of the
Learned
applicant.
Counsel, kindly bear with me.
Yes.
The property which has been gifted through the gift deed is premises number Z3 by 103 by K. Do you have a copy of the plaint?
Yes, I have annexed the plaint at page 12.
Yes, go through the premises number. of the schedule mentioned in the plaint.
My lord, the plaint has been filed by the plaintiff. If something be wrong in the plaint, I'm not responsible for that, my lord. But actually the thing is that, my lord, there is no K.
Yes, there is no
K has
K.
been-
That is the prime concern. If the suit does not involve this property,
But
then
my lord,
how can
my
you
lord,
be added as a party in the suit?
plaint may be wrong, my lord. After some times,
Learned
my
counsel,
lord, your
learned-
lordship can listen.
one thing, learned counsel. Today, no order is being passed. You go through the plaint. Whether there is that Z3 by 103 by K or not. Go through the plaint and
One
apprise
more-
the court on the next day.
One more submission, my lord. Suppose, my lord, the plaint is like that.
Yes.
The
So-
plaintiff
so-
has, the
yes.
plaintiff has right to file a order 6 rule 17. I have been ousted, but order 6 rule 17, there is no bar to give the plaintiff, and he will.
If at all it is
Then, my
allowed,
lord, I have
if-
gone, my lord.
If it is at all allowed, amendment is allowed, then in that circumstance, the schedule will change.
Yes, my lord. They will be inserted only.
Then there will be a separate cause of action for you to file an application under order 1 rule 10(2). Am I clear?
Then I shall have to just watch and see, my lord, whether the
Yes,
order
yes,
6 rule 17 has been
yes.
filed or not.
Because, am I clear now? From the schedule mentioned in the plaint, it is not tallying with the schedule mentioned in the gift deed. What has been mentioned by in the impugned order? Let us see.
In the order impugned, there is no schedule.
There is consideration of the name only.
Yes,
Apart
my
from
lord,
that,
only my lord,
the
in the
premises number, the premises number has not been. In addition to that, premises number has not been considered.
my lord, in the written objection filed by the plaintiff,
yes,
also they have not raised anything else except
Yes.
the name, my lord.
Yes, except the name. But on scrutiny of the schedule mentioned in the plaint and the schedule mentioned in the gift deed, it appears that both the schedules are different. Am I clear, learned counsel?
My lord.
Have you got it?
Yes. But that is the technical mistakes maybe, my lord. My lord, for that, my lord, your lordship be kind, be liberal to allow the order 1 rule 10.
How
My
can
lord,
it
even
be?
the Honorable
No, no,
Supreme
no.
Court has said, my lord. My lord, I am
the-
only asking to defend the case. If I shall be
Learned counsel,
not,
learned counsel, one thing,
ousted.
one thing, learned counsel. The suit involves this room, and you have been gifted that room. Can you be made a party? Can you be added as a party involving a suit which involves this room?
At the first instance, I shall be ousted, my lord. Even I should have been allowed to speak something over there.
Counsel, I have explained to you by giving an explanation. The suit involves this property, this room, and you have been gifted the room adjoining this one.
Maybe, my lord, technical mistakes appears on the face of the record of the deed, or maybe in the plaint.
No.
Only for K, my lord, I shall be ousted.
You have the opportunity. If it is added by order 6 rule 17, fresh cause of action will arise, then you will have the opportunity to be added.
Then your lordship kindly pass the said order.
Which order?
If order 6 rules and any
No.
changing in the plaint.
How I'm explaining to you, but that cannot be mentioned in the order.
Then my lord, every time I shall be looking as a hound dog before the learned court below, my lord, whether they are filing the order 6.
That you will have to. Then supplementary affidavit. Supplementary affidavit has been filed on behalf of the petitioner, and an annexure to the said supplementary
Or my
affidavit.
lord, your lordship kindly give me one opportunity. I shall ask to my client why K has been not there. A short date your lordship kindly give. I shall talk with him. Particular your lordship question that why the K is not there.
When to be kept?
My lord, 2 weeks. My lord,
2 weeks.
My lord, he has went to the Uttar Pradesh. My lord, he has went.
No, cannot be. You
Then
shall have to.
As your lordship, I shall talk with him.
You shall have to apprise the court on 24th Monday. After hearing the learned counsel, no, supplementary affidavit. What else? Has been filed on behalf of the containing a deed of gift. Containing a deed of gift, let it be kept to the record. Full stop. Hello. After hearing the learned counsel at length, and at the time of passing of the order, the learned counsel sought for an opportunity to apprise the court as regards to the discrepancy arising in respect of the premises number appearing in the schedule A of the plaint and that appearing in the schedule of the deed of gift. Full stop. The prayer seeking accommodation is allowed. Let the matter appear on 24th of August. 24th of August. Topic কিছু আছে? Twenty-fourth of August at the top. পার্ট হার্ট আছে, তাহলে পার্ট হার্টের পরেই হবে। পার্ট হার্টের পরেই হবে, ঠিক আছে? তাহলে এটাকে পার্ট হার্টেই ঢুকিয়ে দেবেন। পার্ট হার্টে ঢুকিয়ে দেবেন, ঠিক আছে? Let the matter on 24th of August under the heading part heard. It will appear on 24th of August under the heading part heard. Learned counsel, you will have to apprise the court to clarify as regards to that Z/3 by K. হ্যাঁ, actually ওই ফাইলের সাথে থাকবে, ওই এনভেলপে ঢুকিয়ে দেবেন। যে দিয়েছে পিটিশনার যদি দিয়ে থাকে পি দিয়ে দেবেন, অপোজিট পার্টি ঠিক আছে, ওটা জেনে নেবেন।